So now you're in trouble. Actually, on that point, since we didn't talk about this earlier, my hope is that we can have a very candid conversation in this group and that you'll be honest with your questions. But because we do have members of PJCs here and members of PJCs that might consider cases or might be considering appeals, I want to be very careful that we don't ask questions here about current cases that are pending or might be pending before your particular commissions. So if you're drawing on examples from the past that are things that are truly hypothetical, that's fine. But let's be very careful not to cause a need for entire commissions and to recuse themselves by virtue of our having had conversation about a case in this space. Though I would, as much as I'd enjoy seeing how Valerie, the Synod stated clerk, handled the mass recusal of her entire permanent judicial commission, I don't want to cause that particular problem today. All right, anything else? Well, then we'll go on to talk about disciplinary cases and the PJC. A phrase that some of you lifted up, actually a lot of you lifted up, doing what the secular judicial system cannot do is a key idea as we talk about disciplinary cases, because there are so many elements of our process that feel sort of like the criminal justice system. And some of those principles that are shared with the criminal justice system, that's not an accident. The criminal justice system was conceived in part to have some of those same goals that are preamble to the rules of discipline names. Where do we send people when they've been convicted of a crime? We send them to the penitentiary, the penitentiary. It was conceived of as a place to facilitate penitence, to rehabilitate and to restore. I think a lot of us would say that is perhaps not what they do now, and it certainly doesn't always work, but there is a reason that there are some similarities between our process and the secular criminal justice system. At the same time, it's important to realize where they aren't the same, what is different and why. Here's a brief overview of how a disciplinary process works. This is the brief overview. We're going to dig into some of these steps as we go along. We start by receiving allegations. Now, I'm using the word allegations in this spot as distinct from charges. There are no charges until an investigation has been completed and an investigating committee has chosen to bring them. At the start, all we have is an allegation. And in our system, that's a written statement of an alleged offense that's prepared by someone, delivered to the stated clerk. The stated clerk facilitates the formation of an investigating committee, which conducts a thorough inquiry. None of that involves the PJC. This all happens apart from your involvement, and it's entirely possible that the investigating committee will not file charges, and you'll never even know it happened. In fact, those of you who've never had a case, I imagine that probably has occurred in your presbyteries, that an investigating committee simply determined that not to bring charges. But when they do conclude, an investigating committee, that there is probable cause to believe an offense was committed and that they believe that those charges can be proved using the available evidence, they will bring charges. They will file them with the stated clerk of the presbytery, who will send them on to you. Now, there is one possible step along the way before that. They might come to the end of the process, decide that they believe an offense was committed, decide that they could prove a charge, but also want to offer the accused an opportunity to achieve a different resolution, to avoid a trial. And so what they might do is prepare what is sometimes called an alternative form of resolution, an AFR. Another bit of language that the Book of Order uses is settlement agreement. And what that would mean is that they are identifying particular charges to which the accused is willing to plead guilty and a censure to which the accused is willing to agree, that they will jointly present to the PJC for its approval. And if the PJC approves by a 2/3 vote such an agreement, that becomes the judgment of the PJC and the decision of the Presbytery in that matter. But note, this agreement is in fact a guilty plea and a finding of guilt and a particular censure. It doesn't make it go away. It doesn't brush it under the rug. It doesn't make it confidential. When a PJC approves an alternate form of resolution, it is a decision of the PJC. What's different about it is that you don't get to do any of the deliberation. You don't hear any of the evidence. You don't decide for yourself what the censure should be. You vote yes or no on this proposal that's been brought to you. If there's not a resolution, either because you don't approve it or because they didn't try one, they simply bring you the charges and you begin the process of a trial. The investigating committee becomes the prosecuting committee, and they and the accused are the two parties before you in a case that moves forward. You'll conduct pretrial proceedings, you'll conduct a trial, you'll have a deliberation, you'll make a decision on each charge. For those that you have found guilty, you'll impose a censure, and then you'll publish your decision by sending it to the stated clerk, who will read it at the next meeting of Presbytery. That's a brief overview of disciplinary process for the PJC. Now let's dig a little deeper. Before any charges are filed, there are a couple of ways the PJC can be involved. These are the exceptions to the rule that you're not involved until charges are filed. One of the ways that that PJC members sometimes get called on at the very beginning of the process is when the allegation that the stated clerk receives is an allegation of sexual abuse. And sexual abuse has a particular definition in the Book of Order. It is sexual conduct that involves a child or an adult who lacks the ability to consent, or it is sexual misconduct that involves a misuse of power, or a lack of consent, or an assault. There's a definition in the Book of Order of sexual abuse. In all of those cases, the first thing the stated clerk does is go to the moderator of the PJC and says, I have received an allegation against a minister of sexual abuse. I need you to appoint 2 members of the PJC to read the allegation, conduct a very brief inquiry, and decide whether to place the minister on paid administrative leave. The 2 members who the moderator appoints, who can be off that list of former PJC members, those 2 people have a pretty huge amount of power in our process, an unusual amount of power for us to put in 2 people's hands, because their decision is final. And they can put the person on paid administrative leave until the end of whatever judicial process follows. And that would mean they could not participate in any pastoral activities, any minister responsibilities. There's an inquiry that they have to make. They have to hear from the person who is accused, and you can see there the language. They are to determine whether the risk to the congregation and the potential victims of abuse, when considered in light of the nature and probable truth of the allegations, requires administrative leave or other restrictions. The other thing that's those 2 people, one of the reasons I encourage Presbytery PJC moderators to appoint people off the former PJC roster is because once they've been part of that process, they can no longer participate in the trial if that were to move forward and include charges. So those 2 people, if you have a 7-member PJC and you put 2 of them on this, now you only have 5 people available toward your quorum of 4. the other thing is that the job of those two people isn't quite over then, because throughout the process of investigation, that decision on administrative leave can be revisited. So along the way, 6 months in, the investigation hasn't turned up anything. The accused could say, hey, I don't think I really still need to be on administrative leave, and they could choose to lift it. Similarly, if they decide not to put the person on leave, and a month into the investigation, the investigating committee says, the stuff we're finding leads us to believe this person should be on administrative leave right now, they can go back to those two PJC members and ask for that. So there are provisions for continuing to ask that question. That's one way that PJC members get involved in a case before it goes to trial. There's one other way, and that involves the work of the investigating committee. So we're not going to spend time in this training session on how an investigating committee work happens. We spent more than an hour on that with the stated clerks. It's a really important and complicated process, but it's really not the concern of the PJC for the most part, except in this one way. If the accused believes that the investigating committee has behaved improperly because they haven't followed the proper trail of evidence, or they have not allowed the accused to be heard adequately or listened to their witnesses, the accused can file a petition for a review of the work of the investigating committee. And that review is conducted by, again, two members of the PJC appointed by the moderator. So the moderator would ask these two to meet, there's some timelines, to meet with the accused, to hear argument from the investigating committee to explain their process. And they would then prepare a report as to whether they believe the investigating committee functioned properly. There's nothing that happens at that stage necessarily, but that report becomes part of what eventually goes to the PJC if charges are eventually filed. And when the charges are filed, it could be that the accused will make a motion to dismiss one or more of the charges because of improper work on the part of the investigating committee, as determined by these two members who did that review. On the other side of that coin, if you get to the end of the process, the investigating committee decides not to file charges at all, the accuser could ask to review the work of the investigating committee. And again, it's two members of the PJC who conduct that review. If those two PJC members determine that the investigating committee did not fulfill its responsibilities when it decided to file charges, they can do something very powerful. Anyone know what it is? They can order that the investigating committee's work is thrown out and a new investigating committee is appointed and the whole process starts again.
Whoa. That is a lot,
Correct, Elaine, that is a lot of power for those two folks. Now, as it turns out, what the rules say is that a new investigation is conducted. If at the end of that one, for a second time, there's a decision not to file charges, that's the end of it. That particular review process cannot go on in perpetuity, but once it can be restarted and done again. So that's a word to investigating committees to be very attentive that they follow the letter of the law in how they go about their work, because it could all come to nothing if the two members of the PJC think they acted improperly. Again, those two PJC members don't get to be part of any trial going forward if they were part of reviewing and investigating committee's work. Any questions about these functions of the PJC before we move on to other pretrial procedures? Make sure I'm giving enough time, not just racing through. You all look relatively engaged. That's good. We're pressing ahead. So, as I mentioned, charges come to the PJC through the hands of the stated clerk. The investigating committee, the IC, lets the stated clerk know that they have charges or that they have an alternative form of resolution to present. Now, as I mentioned, the alternative form of resolution can happen before a trial is scheduled. It can be the conclusion of the IC's work, or it could be something that ends up negotiated in the days leading up to a trial. Sometimes you gather for a trial and the parties come to you and say, we've negotiated an agreement. They don't have to present it. They can do this at any time up to the moment the trial begins. Here's what has to be in an AFR for you to approve it. It has to specify the charges to which the accused will plead guilty, and it has to recommend a censure. And the PJC has to approve it by a 2/3 vote, just like you have to find guilt by a 2/3 vote on any particular charge. And then, as I mentioned earlier, you vote it up or down. There's not a back and forth. There's not a, we, the PJC, have approved a different alternate form of resolution that we've decided. There's also not a, you need to change these 3 things and then we'll approve it. At the same time, I think it is not inappropriate for a PJC to express its reasons for its decision. And at the conclusion of that process, it is possible that the parties could come back to the PJC, as long as it's still within the 1-year timeline for filing charges, and proceed to trial on the charges and not have to proceed to trial. But if they don't do that, or if the PJC still rejects the alternate form of resolution, then you do proceed to trial on the charges that were filed. So again, this is a popular misconception that somehow a settlement avoids a guilty verdict and makes the problem go away. That is not how our Presbyterian judicial process works. Any settlement at this stage, if the investigating committee has determined that there is probable cause to believe an offense occurred and that they could prove that, they develop charges, which if the AFR is not approved, you go forward to trial on those charges. Any questions? I see a hand, John.
Yeah, Brian, thanks. So I heard 2 things. I heard if AFR is not approved by the PJC, it goes to trial. And then I also heard you say if you're still within the year window and the IC maybe modifies and brings back another slightly different AFR that could be reconsidered?
Right. There is no prohibition on the parties, and again, the parties, remember, in a disciplinary case are the investigating committee, now the prosecuting committee, and the accused. There is no prohibition on the parties coming back to the PJC with another proposed AFR. The only problem that they could run into is that you do still have this timeline in the Book of Order that says charges have to be filed within 1 year of the convening of the IC. So if they waited till the last day of the year before they brought you their AFR and you reject it, then they really can't come back with a whole different set of charges because it's too late. You're gonna have to go with the charges they filed in the first place. Now, having said all of that, the Presbytery PJC does have the authority to extend the timeline on that 1 year if the parties are pursuing settlement possibilities. It says that explicitly in the rules of discipline. So I would say under that scenario, if I were the prosecuting committee, I would say, we'd like to move that that we toll the timeline, that we put a pause on this 1 year deadline so that we might pursue settlement possibilities. And usually the PJC should issue a ruling that says something like the parties have an additional 60 days, after which we will proceed to trial on the charges as originally filed, or something like that. PJC has a lot of authority. And it has all of the authority it wants to have until it's challenged. So if what you're moving toward is a settlement, towards something that is mutually agreed that nobody's going to challenge, the PJC has a fair amount of authority. Now, if something gets appealed to the Synod, and you've done something that's outside the bounds of the Book of Order, there's a good chance that's going to have a problem. Other questions? And I will say that there's enough of you that I can't see all of you on one screen. So if you are waving your hand, I may or may not see you. You may want to use the raise hand function in Zoom if you're trying to get my attention. All right, then we'll move on to other pretrial procedures. Let's say there is no AFR, or maybe you've rejected the AFR, and the charges are filed and you're moving to trial. Within 30 days after charges have been filed, there's a pretrial conference, and the Book of Order is really explicit about what happens at this conference. It includes the moderator and the clerk of the PJC. It also includes the prosecuting committee. It includes the accused and their counsel, and the stated clerk is also present, though not part of deliberations. They're there. It's a pretty formal event. It begins with a reading of the charges that have been submitted, and the moderator of the PJC announces that the accused has the right to counsel, and ensures that they have it. When a person is charged in our process, the presbytery is required to provide counsel if the person is unable to secure it for themselves. That is not a requirement merely when they are being investigated, but it is required if charges are filed and the process is moving forward through the disciplinary process that way. I should note that that requirement does not mean that they get to choose whoever they want to be their attorney, and that attorney gets to charge them whatever they want to do that work. If the presbytery is providing the counsel, the presbytery gets to set the parameters of that representation. So it could be that the presbytery has on hand a group of pro bono attorneys to do this work. It could be that the presbytery says you can find whatever attorney you want, but we're only going to pay them $150 an hour, or whatever it is the presbytery decides. But that is up to the PJC, and it is not. It's not a complete blank check to a person who is accused in these cases. At that pretrial conference, after the note that the person has a right to counsel, the prosecuting committee goes on to state the names of the witnesses they intend to offer and the evidence they intend to present. Descriptions of any records that will be presented are provided. You don't have to provide all the evidence in that hearing, but you have to say what it's going to be. The moderator and the clerk will determine any matters, will rule on any motions or questions that are raised at that meeting about how things will proceed. But one of their goals in that meeting is to narrow the items in dispute as best they can. So something that I encourage PJC moderator and clerk pairs to do is to get the parties to work toward a stipulated set of facts. Here are the things we agree to in this case. Sometimes you can find those things in the charges and the things that have been presented so far. But the more that you can settle ahead of the trial, the clearer and easier the trial itself will be. You also can encourage the parties to seek a resolution, to see if they might agree to the kind of alternate resolution that we've been talking about. You can't coerce that. We can't force them. If the investigating committee is not interested in pursuing an alternate form of resolution, they do not have to. But you can try to get the parties to come together, at least in the areas they can. This is also the place where what I mentioned earlier, the reviews of the IC procedures would be considered. It is even possible for the moderator and clerk to dismiss particular charges at this hearing. If they do that and they issue an order dismissing charges, that of course is going to be subject to review by the full PJC. Finally, the last thing that happens is you schedule the trial. It can't be any sooner than 30 days after the pretrial conference, but you schedule it. I think the reason they have you schedule it there is that they want the attorneys and the participants who are present to make sure that they have it available on their calendar so you don't have to schedule it again. And you order the parties to appear, and it says in the Book of Order, nothing more shall happen at that meeting. So it's not a full inquiry into the case. It's not an opportunity for the moderator and clerk to render judgment on the substance of the charges. It's not a chance for either party to rail against the other. It is what it said. Then what happens before the trial is that 10 days after, so 20 days before the trial, the accused needs to provide their list of witnesses. The prosecuting committee gets one more chance to add additional witnesses after that. Questions about the pretrial conference? Like I said, even if you're not a moderator or clerk of your PJC, don't think this doesn't apply to you. You might someday be one. Mm-hmm. Oh, we have a question from Neil.
Is there any provision for the PJC to have council representation themselves?
For other members of the PJC who are not the moderator or clerk, you mean?
Right.
That's a great question. This is one of those things where the Book of Order is silent. So it doesn't say they can't come. In fact, it doesn't say it's a confidential proceeding. So in theory, they could be there. They don't have an official role. So there's not going to be anything that the commission votes on as a commission. But in theory, there's no reason they can't be there. At least not prescribed in the Book of Order. I might suggest that there is one reason I might not encourage them to be there is just that the more the PJC is exposed to the case outside of the context of the trial, the harder it might be to maintain an objective focus only on the facts and evidence that are presented at the trial. So the moderator and clerk, by virtue of their office, are asked to render kind of those preliminary judgments, but that saves the rest of the PJC from sort of being infected with the rest of what is discussed at these events that may or may not ever be admitted as evidence in the trial itself. Does that make sense? So there may be some reasons to encourage PJC members not to be part of the earlier stages of the process, but it's not prohibited. I'll lower Neil's hand. Anyone else? Okay. Let's see. Where are we here? I'm looking at the time. We have just a little more time that I'll get us a little further, and then we'll take a break. Let's talk about trials, and we'll take a break before we get to deliberations. Trials have, there's some general things that we should talk about trials, and then we'll talk more specifically about how they go. These are, we're talking here specifically about let's see here. I am speaking very specifically about disciplinary trials, but there's a lot of similarities with remedial cases, and so it's worth paying attention to both things. I'm sorry, friends. I want to make sure. Yes, we're still talking about disciplinary cases. So we'll come back to remedial cases later, but there are some overlaps. Trials in our system are conducted with a lot of formality. And this is one of those places that some people want us to be more different than the secular system than we actually are. But like the secular system, we try to maintain a certain set of processes and decorum that is designed to keep the process trustworthy, to provide for clarity, and to ensure that that in our informality, nobody's rights are being trampled, nobody's due process is being violated. And so we do conduct them formally. We convene with prayer. We sit in a certain way, at least before we were doing all of these by Zoom. We would have the commission at one spot in the front of the room, separate from the parties. That's part of our process. Another part of our process is that parties are entitled to be represented by counsel. The counsel does not have to be attorneys. What they do have to be, every person who serves as counsel has to be a member of the Presbyterian Church USA. Why would that be? Let me just invite people to unmute themselves. Why do you think we require people to be Presbyterians to be part of this process?
Better understanding of the charges?
One would hope that Presbyterians would have a better understanding of what's happening. I don't know if it's always the case. Zach?
I would think because it's an internal judicial process, it's something that is about who and what we are as the church. And particularly with that preamble, there's so much that talks about restoration within the body. And so you can't have somebody who is outside of the body, like that has to happen from within the body.
Right. Why would we, when we say this is a theological process and not a legal one, why would we invite folks who have not agreed to share our theology to be part of that process? Martha?
Similar to what Zach just said, the language in the preamble about being the community of believers, about advancing the 6 great ends of the church. These are things that hopefully we know well and are a part of our approach to everything that we do. Hey, and so we're going to be bringing this to, hey, you know, in some ways we come to our greatest understanding and achievement of these ideals during times of conflict. And so someone from the outside who doesn't know what these things mean, it might be a good chance to explain it to them, but they won't necessarily advance the work.
Well said. Elaine?
Well, and I think what we're saying, all of us, is that our polity grows out of our theology, and that's what we share.
Yeah. Amen. Very well said. Bruce?
Isn't this much like, in the secular sense, a jury of your peers? People that do understand?
Yeah, I think there might be some of the same principle at work. Of course, we're talking here about not only a jury of your peers, but lawyers of your peers as well. But yes, there is something about us all having made kind of a common commitment, a common expression to the covenant. And in fact, also a commitment, a promise when we became members to participate in the life of the church, to abide by the discipline of the church. If you have people who are speaking in our PJC proceedings, who have not submitted to the discipline of the church, there's no accountability for them for how they conduct themselves in the process. Any Presbyterian who stands before your PJC as counsel, knows that they themselves are subject to discipline in the church if they lie, if they behave badly. And this is I think this is an important expression of the covenant that we make with each other. One of you lifted up the significance, to emphasize the significance of membership as one of those phrases from the rules, the preamble. And I think this is one of those places that happens. Being a Presbyterian is important because it expresses our common covenant that we're living into through this process. The way trials unfold, the moderator of the PJC usually makes initial decisions, rulings on particular questions of procedure or evidence. If there's an objection to a piece of evidence being offered, if there's an objection to a question that an attorney asks, the moderator, just like a judge in a courtroom, makes the ruling. But unlike in a courtroom, if either party wants to appeal the moderator's ruling to the full commission, they can do that. Also, any other member of the commission can do that. Moderators are truly moderators. It's the full commission that has authority in our process. Question from Martha Kynard.
Just confirming, back to who can represent. It doesn't have to be an elder. You don't have to hold an office. You just have to be a member of the Presbyterian Church.
That is correct. You do not have to be an elder, and you also do not have to be an attorney. A lot of them are, but sometimes attorneys, and I mean this with all respect to those of you who are attorneys, sometimes it's harder for an attorney to be an effective counsel in our judicial proceedings because they keep confusing the process that we are undertaking and the ways that it is different than secular legal process. So one of my quiet words of advice to those of you who are on PJCs, I often encourage presbyteries to make sure that they do have some attorneys on their PJCs. But it's not because I think attorneys are more qualified to render the judgments. It's because you need some folks who can basically stare down and not be intimidated by the attorneys who appear before you and try to bowl you over with legal stuff. Having said that, I know a lot of attorneys who are incredibly faithful, excellent advocates in Presbyterian settings who understand very well the distinction between secular work. And I even know some of them who have said to me that if they could make a living doing it, it's Presbyterian judicial process that they really enjoy and find fulfilling. So take that for what you will. Some of my best friends are attorneys. After the moderator rules, ruling majority votes of PJC can sustain or overturn those decisions, and you just move on. If something is particularly complicated, sometimes the PJC even needs to take a little break, and you can recess a proceeding. One of the things I told the stated clerks when they're talking about where to have trials is that there needs to be a space that the whole commission can retreat to for brief conversation, brief deliberation on decisions they need to make. If you're having a Zoom process, there needs to be a use of a breakout room, or even a separate Zoom call, so that members of the PJC can deliberate privately, sometimes even in the midst of a proceeding. The quorum, as I mentioned earlier, is a majority of members. If that loss of quorum happens during a trial, that's catastrophic. It's an immediate mistrial, and you have to start over from the beginning. My advice to PJCs is that if you are flirting with not having a quorum, you should vote to augment your numbers by drawing on that list of former members. So that should something happen during the trial, someone's disqualified, someone has a family emergency, you don't fall under the minimum number you need to proceed.
Brian?
Also, oh, yes.
Bill, if that happens in the middle of a trial, you lose a quorum, do you go back and restart the trial, or do you go all the way back to the pretrial procedures and start back there?
What the book of order says is you restart the trial from the beginning. So I would probably take the letter of the law there and say that's what you do, because the pretrial procedures didn't involve the full commission anyway. It just involved the moderator and clerk.
Even if
So-
there's a new moderator?
Oh, you mean if the moderator is now disqualified?
Right.
No, I think the commission is personified not in the moderator, but in the commission itself. So I don't think that would require restarting the pretrial.
Good. Thank you.
I don't know if that was a hypothetical question, but I'm delighted to answer it. Anyone else on that? I should also say this need to maintain a quorum and this need to count people who are present applies during the trial, but also during the deliberations. It is any time the commission is gathering to work on the case. So after the trial is adjourned and you have retreated to your room to make your decisions, you can't start deliberating until everybody is there. And you have to stop deliberating anytime anyone steps out. Someone needs to go to the bathroom. You say, we're taking a 5-minute recess. That may seem incredibly inconvenient. It is incredibly inconvenient, but it is the process. Every deliberation has to involve everybody. And if for some reason a deliberation proceeds while someone is absent, that person can no longer participate in the remaining work on that case. They can't vote on the final outcome. Any other questions? Oh, there weren't any questions. I was working my way through the list. Proceedings are usually open. That is the assumption. But the book says the PJC can decide to close a trial. My advice is that I can't think of too many reasons that that would be necessary or wise. I think our process is better when we are transparent and nobody looks like they're hiding anything. I guess an occasion that I think might be the right one to close a trial would be if there's a particularly sensitive allegation and a victim is testifying in a way that it would be hard to have a room full of people. Maybe you can think of other examples, but by and large, our presumption is that meetings are open, including trials. The only thing that's private is the deliberation after the trial. Julie has a question.
Does open mean open to any member of the Presbyterian Church USA or open to anybody who wants to wander in off the street?
Yeah, I'm not familiar with any cases where the audience has been limited to Presbyterians. I think it's actually open.
Thank you.
Yeah, PJC could try it. I mean, you could vote that you're going to open it, but not fully, but I don't know of any precedent for that. Karen has her actual hand, not her virtual hand. Yes, Karen.
Yeah, Brian, are you saying that we can close the proceedings like just during someone's testimony and then open it back up?
Yes, I think you could do that. I think the consideration you'd have to give would be whether there's any closing it intermittently somehow does not support the cause of justice. But I can't think of why that would be unjust. I should note, when I say closed, the closed to everyone except the parties and their counsel. The counsel and the parties always get to be there. And the accused, no matter how sensitive the situation or the nature of the allegation, the accused still gets to be present throughout their own trial, even if that's uncomfortable for someone offering testimony. Now, I should also say there are other ways to offer testimony, and we'll talk about the rules of evidence after our break, but depositions are allowed. And so in these particularly sensitive situations, you might, a council prosecuting committee might be wise to actually submit a deposition from a particular witness rather than bring them into the trial. Christiane.
Hi. This is probably a silly question, but who pays expenses, like for witnesses, and if they have to travel or stay overnight or whatever?
Yeah, that is not a silly question at all, and the Book of Order is explicit about it. The expenses of a witness are paid by the party that calls them as a witness. So the council, the prosecuting committee, which of course represents the council, would pay the cost of prosecution witnesses. The accused would be responsible for paying the expenses of their own witnesses. The expenses of the PJC itself are all paid for by the council. And if there's a mistrial and people incur expenses that then go for nothing, then the council also has to pay those expenses. So don't have a mistrial. John.
Yes, thanks. On to witnesses. Can you talk about sequestration of witnesses?
Yeah, there is a provision in the book that if it is requested by the parties, or by one of the parties, witnesses may be required to leave the room, to be excluded from the proceedings while other witnesses are testifying. It's not required, but it may be requested. Let me see. I think the PJC would actually vote on it if it's requested. But yes, that is something that can happen as part of a trial.
And do they have to be kept separate from each other and/or proctored if they're kept in a common room, or how's that handled?
It's not explicit in the rules of discipline. Some of you who do have experience in the secular legal system might be better able to speak to that. I've not been part of one where that's happened, but I assume there is sort of a good faith expectation that witnesses are not comparing notes outside the room, but maybe I shouldn't have so much faith. Ernie has a response to that.
The fact, the fact that the trial is open doesn't mean that you have to rent a huge hall and let everyone who might want to attend. You can reasonably limit the number of people who can attend. And I suppose you could even limit which side they were coming from. I mean, so that you don't have one side bring in a lot of people to sort of pack the room.
Yeah, I think the PJC has a lot of discretion over how it manages its crowd control and that sort of thing. The only thing I would say is that anything you do to limit observation probably requires a 2/3 vote under the rules of discipline. And by the way, if any of you are having a trial that you have a whole hall of people that want to watch a Presbyterian judicial proceeding, would you please let me know? I would like to also be in the audience for that event. There were the days, I'm the executive director of the Covenant Network of Presbyterians. There were days when certain cases did attract major crowds. Lori.
Brian, I was going to ask that, how many of these trials are attended by so many observers? And I guess they're just different. Each one would be different, but does the PJC put out an announcement that this is going to happen to the in the life of the presbytery, or is just this sort of an inside job?
So this is an area that the Book of Order is not explicit about. The stated clerk is not required by the Book of Order to publicize that a trial is happening. So I think a lot of trials happen without anybody noticing, not because someone is trying to keep them secret, but just because nobody knows about them and it doesn't affect them very much, so they don't really pay attention. But I would probably suggest that however you normally notify people about meetings of presbytery entities is probably a good way to notify about this. If you have a presbytery calendar on your website, this can be on the calendar. It's not secret. The other thing, and we touched on this with the state clerks, is if hearings and trials are happening online now, if they're happening in a Zoom call, you do have to think about ways that you have an open meeting that's on a Zoom call. So the way the GAPJC does this, we do routinely announce our hearings and trials. We have a website for that purpose, so people who are interested can see it on the website. But what we have begun doing is when we have Zoom hearings, we don't publish the Zoom link. That's only for people who are participating in the trial. But we do live stream the process. So that Zoom call is live streamed through our webpage, but you can observe it, you can't participate in it. Incidentally, if you go to the GAPJC website, you can actually watch the live stream of our last couple of hearings because it's still posted there. You can watch the recording. And that's actually a new thing. That's never been, more people are able to participate in General Assembly level judicial process today than ever have been before. That's only because of the pandemic. Otherwise, we'd be meeting in a hotel ballroom in Louisville. Martha.
I assume open also means open to the press.
Yep, absolutely. Unless you vote to close it. Yeah. And I don't think you could exclude just the press.
Right.
Yeah. Good questions, everyone. Very good questions. The last item on this list, and then we'll take a little break. The accused is presumed innocent. That part is like the secular judicial system until guilt is proved. And the standard for proving guilt is, the language is, beyond a reasonable doubt. So we don't refer to someone as guilty or as having been convicted or having done something according to our process until that guilty finding by a PJC. They're presumed innocent even after they've been charged until guilt is proved. Any questions about that? Okay, we're going to take 20 minutes. We had a little break earlier. Are you all comfortable? Is 20 minutes enough? We'd promised kind of 30 minutes, but if 20 minutes is enough, I think that'd be great. So let's regather at let's do 3:40. We will start right at 3:40. We'll continue conversation about disciplinary trials, and then we'll move on to conversation about remedial trials. Have fun, take a break. See you soon. Don't log off? You don't have to log off. If you do, you can always come back, but mostly I suggest you just turn off your camera and come back in. All right. Are we at 3:40? We are. So we will get back on track. I will share the screen and we'll continue talking about disciplinary trials. There's a game of charades going on around me. 3 syllables. Process. That's weird. All right, so we are picking back up with disciplinary trials and how they go. Here's how they start. And as I mentioned earlier, the Book of Order is pretty prescriptive about what has to happen. Some for reasons that are obvious and good and important, and some just because that's the way it is. But either way, it is the way it is. Would love to hear your reflections and questions about it along the way. Every trial begins I'm sorry, every trial begins with the moderator reading the preamble aloud. Now, I will say that my friend, the Assistant Stated Clerk of the General Assembly, Flor Velez Diaz, she suggests that every appellate hearing also begins with a reading of the preamble, and that's what we do at the GA-PJC. In fact, she goes so far as to say every meeting of an investigating committee should begin with a reading of the preamble. It is the foundation theologically for our rules of discipline. After the reading of the preamble, the moderator enjoins the members of the commission to remember and regard their high character as judges of the council of the Church of Jesus Christ. And I have to say, I've been on Presbytery and GA PJCs. I've been part of a dozen trials and hearings, well, more than that, a couple dozen. And every time that still gets me. You know, in a way that's always true. Every vote we take at a Presbytery meeting is supposed to be done in light of who we are in Jesus Christ and our responsibilities to be faithful stewards and wise discerners. But it feels especially important given the small number of people and the significant consequences of these judicial decisions. And so I really do encourage you as members of the PJCs to listen to that enjoinment from the PJC moderator and take it seriously. It's a powerful moment. The very next thing that happens, you get down to business. And the first part of the business is inviting the parties to object to the composition of the commission, to who is at the table. They have the opportunity to challenge the participation of any particular PJC members. Now, the reasons a PJC member might be disqualified from participating, I would hope in most cases, if a PJC member knows themselves to be disqualified, they would already have recused themselves, so they don't need to be challenged. But occasionally there will be a challenge. The grounds for not participating or for challenging a participant would be when they are personally interested in the case, so they have a conflict of interest, or it could be that they're related to one of the parties, or, and this is where there's some judgment sometimes, whether they have been active for or against either party. Excuse me. Do they have there's a challenge here, especially at the Presbytery PJC level, because we all know each other. At least on some level, there's a lot of personal relationships among ministers. There's supposed to be. Presbytery is a covenant community. And so there's a built-in tension when members of Presbytery are asked to sit in judgment of one another. But that tension is built into the process and is not in and of itself grounds for removing a PJC member. The fact that I know the accused does not make me unable to wisely discern whether they have committed an offense. What could make it difficult is if I've spent a lot of time talking with them about this offense, or whether I have been closely connected to people who were personally affected by this offense, or whether I know more things than are going to be presented at the trial. So I may have to search myself and decide if I can be an objective, fair, faithful discerner of the process and of the person's guilt. But if I have decided to stay, the parties still can challenge me. And it's very simple. It's a very simple process. The party raises the objection. The other party has an opportunity to respond if they wish. And then you take a recess. The PJC leaves, goes to another room, and all of the other members of the PJC, other than the one who's been challenged, vote on whether they get to stay. Majority rules. Questions about that process? The other thing that happens at this stage is that any preliminary objections are decided here. So if there was a motion to dismiss some charges, possibly rooted in the review of the investigating committee's procedures, that this is the point at which the PJC could vote to dismiss some charges. It's also an opportunity for the prosecution to amend the charges. And that is legal to do right up until this moment of the process. But they can only do that if doing so would not prejudice the case against the accused. So you can't do a kind of a bait and switch and at the last minute charge them with something else entirely. Rather, this would be to sort of refine the charge based on evidence, possibly even based on some sort of agreement to stipulated facts, things that are no longer in dispute. We're going to focus here on the things that we now are going to be focusing on proving. So that can happen at this stage of the process. The PJC needs to vote to approve the amendment of charges at this stage of the process. And then finally, when it's time, each charge is read and the accused is asked whether they plead guilty or not guilty to each charge. If they have pled not guilty to any of the charges or have refused to enter a plea of not guilty is entered for them and you proceed to trial. If they plead guilty to all of the charges, you'll proceed then directly to the censure phase of the trial. What in criminal process you would call the sentencing phase. We refer to it as censure. Questions about these opening matters at the start of a trial? All right. Then here's how it goes after that. It's fairly straightforward, and this part will feel pretty familiar if you watch any courtroom drama. The prosecuting committee speaks first, and then the accused. They each get to make an opening statement. Then they present evidence. The prosecution makes their case. Evidence can take many forms. It is usually presented through testimony by witnesses. They call a witness. The witness is administered an oath. The prosecuting committee asks them questions. After they've asked all their questions, the counsel for the accused is invited to cross-examine the witness. And after that, the prosecution is invited to redirect. They can ask any follow-ups based on things that were raised in the cross-examination. When the attorney's examination is complete, or when, I shouldn't say attorneys, the counsel's examination is complete, the members of the PJC, and this is something that might be different than your average courtroom drama, members of the PJC can ask questions of any witness. So counsel gets to ask the questions first, then the members of the PJC can ask questions if they have any. Those questions, by the way, still have to be relevant. An attorney or a counsel rather could object to a question from a PJC member, and the moderator could rule their own PJC members' questions out of order. In order to be at the same time, evidence is introduced. It's usually introduced through witnesses. So if there's a document you want to introduce into evidence, you would offer it to the commission, and then you would ask the witness questions about that document. It doesn't say in the Book of Order that you have to have a witness on the stand to introduce a document into evidence. So that simply could be introduced. And we'll talk a little bit more about rules of evidence. At the end of all of the witnesses for the prosecution, the accused gets to call their witnesses, does the same. The prosecuting committee gets the opportunity to offer rebuttal witnesses or evidence, and then you move to closing arguments. Again, it's prosecution, then accused. The prosecution has the right of to have the last word.
Brian?
Yes, Bill.
After the prosecutor offers rebuttal, is the accused allowed to do anything further, or is that the end of it?
I think the PJC moderator, in their discretion, could allow rebuttal witnesses if something has emerged in the rebuttal prosecution witnesses that was not covered previously. The PJC has wide discretion, wide latitude in how to structure the time, so long as it is done in a way that is fair to both parties.
Thank you.
Yep. When the GAPJC had an unusual case of original jurisdiction, it was a remedial trial, not a disciplinary trial, of course. The decision was made to offer a total time to each side in order to be fair. And that time included when they were conducting direct examinations and when they were conducting cross-examinations of the other witnesses. So it was divvied fairly. Martha?
I was following in the book of order. You said after the accused completes its examination, the PJC can ask questions. I don't see that in the book of order. Where is that?
So it's in chapter 14. One of the confusing parts of the rules of discipline is that to follow a simple process all the way through, you have to keep switching back and forth between many chapters.
Okay. Yeah.
There's an effort underway right now to propose a new rules of discipline section, a rewrite of the current one. And one of the things it does is it has a section on disciplinary cases, and that everything from start to finish in order is in that chapter instead of making you switch through different sections. So thanks for that question. You're exactly right. The thing you're looking for isn't always
asking a question in the chat.
Oh, Mark has a question in the chat. Do witnesses have to be members of the PCUSA? They do not have to be, but only members of the PCUSA can be compelled to testify. So if one side or the other wants to call a member of the PCUSA, the PJC issues a citation for them to appear, and refusing to abide by a citation could be grounds for a disciplinary case against that person. But of course, people who are not members of the PCUSA can't be cited. They can't be disciplined for not appearing. So instead, they can only be requested to appear. But yes, people who are not part of the PCUSA can be asked to testify in PJC cases.
Yeah, I was thinking in terms of like professional witnesses.
Like expert witnesses? Yes,
Yeah,
you can absolutely call people who are not members of the PCUSA as witnesses. And how you assess the credibility of a witness is up to the PJC. You can assign more or less value based on their background if you want to. Zach?
I was just curious about your experience with that topic of compelling witnesses to attend. As a pastor, I find it to be an interesting topic of compelling a church member to do anything.
Yes, don't you wish you could compel someone to attend Sunday school? That's what I really do.
So I just wonder if you've had the experience of PJCs who have issued citations to compel people to attend and they've just said no. And then if the threat on the other side of that is, we'll have a disciplinary case against you, then I can see that's a person who just leaves church and never comes back.
Right. Yeah. And what you're raising, Zach, this is a good place to digress for a second. What you're raising is, and I shared my honest feelings about this with the stated clerks already, is that our system from start to finish depends on the good faith of all the people involved. It really depends, we don't actually have armed bailiffs in the courtroom. We don't actually have police to go and get the person who's been convicted and put them in jail. Every part of our process demands that the people involved are doing it willingly and are doing it honestly, and are doing things to support the process rather than to muck it up. And if someone decides they're not going to act in good faith, if someone wants to be a bad actor, it isn't that hard to mess with our system and throw the whole darn thing off. So the person who refuses to testify, yeah, there's a process for compelling them, sending them a second citation, which of course is going to delay your trial for 2 weeks, something. In theory, you could actually file a charge, have an investigating committee formed. I don't know of a single time that's ever happened, but maybe it's happened somewhere in church history.
I think you've already hit what I was concerned about. Like, it's a squishy process, but what you said about how that's absolutely right. It assumes and it depends on everybody who's in that process entering into it and being a part of it in good faith.
Right. And, other than new disciplinary processes, there's really no consequences for people acting in bad faith. Unlike, there is no judge holding a person in contempt, for example. There's no bench warrant that the PJC can issue. There's only a new disciplinary process. So you've raised the question that has no answer, which is, we trust that people are going to be good people, and they sometimes are and sometimes aren't. Other questions? So I've already flipped the screen over to the rules of evidence. This actually applies to both disciplinary and remedial cases. The rules of evidence are the same. This is chapter 14 in the rules of discipline, if you want to be checking it out for yourself. By evidence, I'm using that term in the broadest sense. It refers to oral testimony of witnesses, so the examination, cross-examination, direct examination. It also refers to records, to writings, to written documents, to material objects, anything that might be presented to help a PJC make a determination of what is factual, what is true. Certain evidence is admissible in our process, and certain evidence is not. To be admitted, evidence must be relevant. So if a piece of evidence is offered where a question is asked that the other party believes isn't relevant to the case, they can object, just like in a courtroom. Objection on the basis of relevance. And it's up to the PJC, first in a ruling from the moderator and then subject to appeal to the whole body, whether a particular piece of evidence or a particular question is relevant. There is a clarifying word that circumstantial evidence is permitted. Circumstantial evidence, as opposed to direct evidence, is evidence that's not based on eyewitness account of a particular thing happening, but rather an account of something that implies something else happened. I heard the gunshot, I ran into the room, and there was a person lying there bleeding. Can you testify that that person was the victim of a gunshot? You can testify to exactly what you saw, and that's circumstantial evidence. Circumstantial evidence is allowed in our process. You as the PJC have to weigh the credibility of that evidence and decide if it's something that's going to affect your judgment. That's something of where the preponderance of the evidence is. Witnesses who are called by either party can be challenged. Bruce asked about expert witnesses. It is acceptable for another party through its questions or through its objections to challenge whether a witness has a place in a proceeding, whether they have the expertise to be part of it, and that's up to the PJC. The PJC may also consider anything else that bears on the truthfulness or accuracy of a witness. So which I think is to say, without, while we have to act with a certain amount of civility, if a witness is not credible, or there's the part of what a counsel can do is ask questions to help illustrate whether a witness is a credible witness or not. If they have a history of untruthfulness, if there's evident inaccuracy in the answers they're giving, that's all fair grounds for examination in a judicial process. There are some rules about who cannot be compelled to testify or what they can say. Spouses may testify against their spouse, but they cannot be compelled to do so. You cannot compel a professional counselor who has been appointed to work with someone to then testify against them, although if the accused or the person who they provided counseling to waives the restriction, then it is permissible to call them if they want to. Counsel, meaning the attorneys, the person representing them, cannot be compelled or even permitted to testify on behalf of their own client or against their own client without explicit permission from that party. As we mentioned earlier, witnesses can be excluded by action of the PJC when other witnesses are being examined. We do always allow cross-examination of any witness who is called, followed by those questions from the PJC. And here's something that I think probably should be emphasized. As much as the dramatic courtroom scene is the stuff that we think of in connection with trials, depositions are probably a really good way to introduce evidence, especially in a proceeding like ours. So this whole compelling the witness to show up at a certain place, a lot of folks don't want to do that, but are more than willing to spend an hour answering questions somewhere. And that's what a deposition can do. You can also admit sworn statements, although the body may have to decide whether they find those credible if there's not an opportunity for cross-examination. But those are all things that the PJC can consider if it wants to. Finally, there's one category of records that in our system are always admissible, and that's the authenticated records of a council or a PJC that the stated clerk has authenticated. The minutes of a Presbytery meeting, the minutes of some other meeting are always admissible if the stated clerk certifies that those are in fact the minutes. Questions?
Hey, Brian, this is Martha. When they do the depositions, are both sides present?
I think that would be the most, yes, I think that's how that should proceed. I suppose you could do a deposition without both sides present, but if I were the other party's counsel, I would challenge it and say if they didn't have the opportunity.
It's probably not really a deposition if both sides are not present and able to object.
Right, I would call that a statement.
An affidavit or something, yeah.
Yeah.
Well, can you present affidavits, written affidavits?
I think the PJC would have to weigh whether that should be admitted. I think I can imagine some scenarios where possibly in the case of victims of abuse, for example, where you might have a scenario where you are submitting a statement rather than cross-examination. But in those cases, I think the PJC would really have to weigh whether that's fair to the accused. Sometimes those things get introduced not in the trial, but at the censure phase of a trial. So I wouldn't say they're always ruled out, but the due process is right there in the preamble, and it's emphasized throughout our rules. And I think giving people no opportunity to respond to things that are defaming to them or prejudicial toward them is probably a no. Becky.
Yeah, just following up on Martha's earlier question, I see that in the section you just covered, rules of evidence, it looks like you were kind of going through that chapter 14 of it. And I didn't see where it says that, and I don't doubt you, but I would like to, want to know where it is, where it does say that PJC.
Bring it on.
Yeah. Where does it say in there that PJC members have the right to ask questions?
Let's see. I think that might be back in D11.
Oh, 11.
Back in the trial.
It's D 14.0302.
Oh.
Yeah.
Okay.
Oh, you're exactly right.
Good. Well, I couldn't see that.
Thank
Look,
you.
I highlighted it.
Good job. Good job. I'm so proud. My work is done
yes.
here.
Thank you. Martha's bucking for an officer of the Synod PJC. That's what she's doing.
Don't say that. She won't talk anymore. Yes.
Brian?
Yes, I see you, but I can't. Craig. You don't have your name there, so I forget. Craig, yes.
Yeah. My question is, do we fall back at all on like the federal rules of evidence, or I don't see anything here about hearsay. Is hearsay objectionable or is it admissible?
Well, hearsay is basically circumstantial evidence, right? This is what someone said. I didn't witness it myself. It is admissible, but the PJC has to decide how credible they find it. So more evidence is admissible in Presbyterian process, according to what I have been told. I'm not an attorney, but what I've been told is that more things are admissible in our process than might be in a courtroom. But that doesn't mean you have to take it all equally seriously. You might say, yeah, okay, I heard that hearsay, but I don't necessarily think that's compelling.
Thank you.
Thank you for the question. Martha. Martha, you're muted.
That was from before. Maybe it's another.
Sorry.
Martha, other
Yeah.
Martha.
Sorry, other Martha.
Yeah, I forgot to unmute. I'm sorry. I had a couple of more general questions that you might or might not want to respond to immediately.
Depends on whether I know. If I don't know it, I won't want to respond.
Okay, that's fine. One question has to do with that intersection between the Presbyterian process and the criminal process, where we might be concerned with the case that there are also legal charges involved. You've mentioned sexual abuse charges, a malfeasance in office and embezzlement. And at some point, if you could talk about how to handle that intersection, that would be helpful.
Absolutely.
The other question that I had is that I'm kind of having a problem with dealing with all of this in the abstract. And it would be helpful to me if you could talk about, if you have a case involving heresy. We haven't had a good heresy trial for a while.
Yeah, isn't that a shame?
And how the witnesses are there to say, yes, this is what the pastor said, or no, I think that's a misinterpretation of what the pastor said. To provide more context with all of this, how it might relate to a specific case, I would find that helpful.
Okay, let me take your first question first. There are times where there are civil proceedings going on concurrently with or potentially awaiting as the church goes through its own process of investigation and discipline. There is an explicit provision in our disciplinary cases section that says the timeline, our deadlines for filing charges and so on, can be put on hold if civil proceedings are underway. And the suggestion there is that it might behoove the church not to try to move simultaneously with criminal process, but rather to wait for that process to play out and see what happens. As we've said a number of times, the church process is different than the criminal process. It's trying to do something different, but at the same time, it can also interfere. And I think in particular, a lot of people won't talk to you, won't talk to the investigating committee you may not have access to a person, particularly if they've committed a crime or are alleged to have committed a crime. So this process just sort of gets stymied if there's actual criminal proceedings underway. And so it's best to put it on hold. You don't have to, but the PJC is empowered to toll the timeline, to push pause. It's a little grayer area if the proceedings are not a criminal case, but something like a divorce. And this actually has come up, where a minister is accused of adultery or marital infidelity. And that is the church disciplinary process is unfolding in concurrence with a legal divorce proceeding. And in that case, folks are sometimes very hesitant to participate fully in the church process. And in a way, it's not really fair to ask either the witnesses or the accused to say things that then might be used against them in court in your process. So that's another case where I think you are empowered to push pause when you think that better serves the cause of justice in your process. Does that make sense? Now to your other question about a good heresy case. I think, I do think that this is one of those challenges. Our system is pretty well built for things like financial impropriety, misconduct of various kinds. It gets a lot murkier when the allegation is bad theology. I have heard anecdotally that those things happen, but I've never actually witnessed a case along those lines. So I'm not sure I can help get past the hypothetical there. Maybe some other people have experiences they can share. I have witnessed cases that are not sexual misconduct per se, and are not crimes, but do sort of fall into the category of conduct unbecoming a minister, or at least that some people find unbecoming a minister. There was a case, for example, it was actually on the PJC of a minister who was alleged, and in fact pled guilty to viewing pornography on the church computer in his office, which the secretary inadvertently witnessed. That amounts to sexual harassment. It amounts to a form of sexual misconduct. At least that was the finding of the PJC. But it's not a crime. And it was the sort of thing that required some real theological reflection, particularly as they sort of decided what charges to file, what scripture or constitution was violated. But they did indeed have charges to file, and the minister pled guilty to them, and the PJC imposed a censure. Richard.
Do these proceedings or documents or moderators or clerks or members ever get sucked into court cases, either as witnesses or as, do these documents show up as, do they often show up as evidence? And is there any, and what kind of liability do we open ourselves up to if we're in a discussion and there's a document where somebody could argue that it's slanderous or libelous? Questions of character and plus I'm a working journalist during the day, part-time pastor, so I'm thinking about this from a different perspective maybe, but.
No, me too. And I think it absolutely is subject to subpoena. There's no question about that. Whether some of those whether some of the proceedings and some of the documents might be deemed privileged in one way or another, I think is probably as a lawyer would have to speak to in more detail, and I see we have a few. But I do think, Richard, you're raising a very good question. One of the things I do always say is that you you have a good reason to tell the truth in these proceedings, and that's because it's the right thing to do, and it's a sin to lie. But you have another good reason to tell the truth in these proceedings, that it's not any more acceptable legally to slander someone in a church meeting than it is to slander them somewhere else.
It was really a question more of frequency, not, I mean, obviously anything can be subpoenaed, but how often does it happen, or does it happen?
I don't think it happens very often.
Yeah.
It certainly never happened to me. I can't think of any cases. I can think of some threats to sue a presbytery for libel over things that have been said in meetings, or that have been posted on the website of the presbytery, reports from committees. I've not actually been familiar with it happening during judicial process. Maybe because there's a both sides situation that allows for response. Bruce, you've patiently been waiting, and maybe you can speak to this.
No, my question was with this presumption of innocence with the accused, can the accused be compelled to testify? I mean, can the prosecuting committee, can they call as our first witness? We're going to call the accused.
The answer is no. They have the right to remain silent. They cannot be compelled to testify against themselves. Our system creates the equivalent of a Miranda warning that allows people not to be compelled to testify against themselves. Take the fifth. They can take the fifth. Any other questions?
If I could just, return for a minute to, okay. And this is Martha again. What I have seen is the judicial process being used to extend a level 5 conflict within a congregation, where people are going through the book of order trying to find things to get the other party on, where it's gone beyond we want to hunt him down and kill him, to we want to hunt him down and make sure that his reputation is totally destroyed from now until forever. So yeah, things that are said in sermons will come up. Minor details of treatment of congregation members will come up. An investigative committee that is really doing their job well can weed out a lot of that stuff. Right. But some of them do actually come to trial. And for good reason, because there is wrongdoing on both sides.
I agree with that, Martha, and I think a good investigating committee can weed some of that out. A good PJC can weed a lot of that out too. And I would encourage moderators to have a pretty, I don't want to say a heavy hand, but to not be afraid to say that is not relevant and therefore it's inadmissible. Move on. That is an acceptable, in fact, I think the appropriate thing when you feel like the process is being abused, to keep it focused to the things that are essential to the process. And if that's irrelevant details or efforts to defame the person, then that's within the power of the PJC to restrain. But you're also raising a different facet of what Zach raised earlier, that it still is possible for people to use judicial process not in good faith, and not because they're committed to this discernment and mercy and what have you that we've been talking about, but rather because it's another tool in their portfolio to hurt someone. I certainly have encountered that in this work in the Presbytery I serve, where you have some frequent flyers who file a lot of complaints. And unfortunately, our process is quite ill-equipped to stop them from doing it, because we keep giving people another chance and we keep giving them good faith responses, even when they're not acting in good faith. But that is our process. There have been some rare occasions, I should say, this is a digression, but where a PJC, or the GA PJC, has said, you have lost your right to keep filing complaints. You are abusing the system. And from now on, rather than your complaint going through all the stages of the process, it will advance directly to the PJC, which will determine whether to allow it to proceed or not. But that is a significant limitation of a person's rights, so it should not be undertaken lightly. And there's really no constitutional basis for that act at a synod or presbytery level. The GAPJC only was able to do it, and that was probably 20 years ago, because there's no appealing what the GAPJC decides. But thanks for that question, Martha. I think you're making a really important point. Lori says in the chat, I'm glad to hear that PJCs have addressed frequent flyers. You know, I wouldn't be sorry if some presbytery or synod PJC would try that and let it be appealed. Because I actually think that would be a good precedent for us to have in the book. But don't mind me. I'm just opining freely. I shouldn't. I'm sorry. Other questions about rules of evidence or anything else we've been hitting on? All right. So we are. You know, I'm not concerned by the way that we're taking a little more time here. We have the time to make up tomorrow morning, and frankly, a lot of what we're talking about here, the principles extend not only to disciplinary cases, but to remedial cases as well. So it's okay. The deliberations phase is what comes after the trial. So they've made their arguments, they've presented their evidence, they've finished with closing arguments. The trial is over. Now you go into deliberations. Some basic things about deliberations. Deliberations are private. All of the PJC members need to be present at every moment, and only them. The stated clerk is not part of the PJC's deliberations. The stated clerk is most important as a trainer and preparer of the PJC, but once your deliberations start, it's your job to do the discerning. Now, the stated clerk is still available as a resource, but the kinds of questions or information you should seek from a stated clerk once deliberations have begun really can't be about the substance of the case or the decision you're about to make. It would be more about process. The example I used earlier, if you can't remember whether you have to vote on every charge, you could ask the stated clerk, who will tell you yes. But you should not ask the stated clerk, hey, when the counsel for the accused argued that G70304 doesn't mean that, was that true? You're going to have to interpret that for yourself. If you didn't sort it out during the trial, you can't get a later bit of input from the stated clerk. Okay? There are other resources you can consult while you're in deliberations. Certainly, the evidence that has been presented is all before you, whatever has been admitted into evidence. You also can consult, and should, previous decisions of the General Assembly PJC, as well as authoritative interpretations that have been approved by the General Assembly, to help you understand what those terms in this relatively thin Book of Order actually have been understood to mean. The best source for that kind of information is the annotated Book of Order, which is available online, and I will show you tomorrow how to use it. Okay? So you do have some constitutional interpretation tools that are completely appropriate for you to use in your deliberations, because they are authenticated records of a council of the church, the General Assembly. They don't have to be admitted into evidence by or proposed by a council in order for you to consider them. As you're going through the process, you can structure your deliberations however you want. You can have a general conversation at first. I will pull back the curtain to tell you that's what the General Assembly PJC does. We immediately after a trial, we have a period of what we call initial deliberations, or sometimes call a straw poll, where everybody gets a sense of where they are in the case. I find that helpful because it tells you whether you need to have a long deliberation or whether you might be headed for a short deliberation, or it helps you identify what is an agreement and what still needs to be discussed. You can divvy up your work however you want, but at the end of the process, you have to vote on each of the charges that was brought to you. You vote on them individually, guilty or not guilty. And in order to find someone guilty, it requires a 2/3 vote of those who are present. That means if you have a 7-member PJC, how many people are required? 5 votes, yes, is more than 2/3 of 7. But if you have a 6-member PJC making the decision, you would only need 4 votes to convict.
Brian, when you say
Yes.
here record the outcome, do you just mean guilty or not guilty, or do you mean 7-2 guilty?
You actually do record the numbers. But record them means you put them in your minutes. They do not necessarily go in the published decision. They can, but they don't have to. I actually always did include them when I was clerk of the Presbytery PJC because it eliminated any doubt about whether we had the necessary 2/3. But you do record them in, this is something that is often overlooked. The clerk is keeping 2 separate documents. They're drafting a decision, but they're also keeping minutes to accurately record the actions the PJC has taken, which are more than just what they've decided to put in the decision.
So,
Ernie, go ahead.
How detailed do those minutes need to be? Do you need to say, we looked in the annotated book of order and we read case so-and-so, or?
No, in fact, they should not be that detailed because the deliberations are private. In my case, they said, or actually I write them for the GAPJC, they say deliberation began at this time, everyone was present, deliberation recessed at this time, but then they record the votes with great precision. When there are any decisions that have to be made, those are all included. Preliminary objections and how they are addressed, that kind of thing. John?
Yes, thanks. My question is, for like recording that, you don't necessarily write, you wouldn't record the names, even for the clerk of the PJC wouldn't record who voted which way. They just vote the numbers. They just record the numbers. Is that right?
That's correct. And the majority never has to accept responsibility by name for their decision. It's the commission's decision.
Yeah.
And the people who vote no don't have to identify themselves either, unless they choose to in a dissent.
And I understand that the actual minutes of a deliberation, private deliberation of a PJC, don't ever really see the light of day, do they?
The only place where they might see the light of day is in the appeal, where they might be a record that is submitted as part of the record, indicating, if one of the grounds for appeal is that the 3 members of the PJC skipped out on the deliberations, you would need the minutes to establish that that did not in fact happen.
Okay.
So the minutes of the PJC, they're not ever reported to Presbytery. It's not that kind of, they're not published in the minutes of the Presbytery, but they could be a record in the case.
But they aren't necessarily automatically a record in the case.
They actually usually are. They use the minutes of the PJC for around a meeting that includes a particular trial or hearing are usually submitted as part of the record on appeal. But they function differently than the decision itself, which is what the parties have to abide by and can object to, or repeal rather. That vote, that 2/3 vote of guilty, there's a definition in the Book of Order about what it means to say guilty. It defines proof beyond a reasonable doubt. And as you can see there, it occurs when the comparison and consideration of all the evidence compels an abiding conviction that the material facts necessary to prove the charge are true. I find that to not be the clearest sentence in the Book of Order, but there it is. This is the definition of proof beyond a reasonable doubt. Does all of the evidence, when taken together, compel an abiding conviction that the facts necessary to prove the charge are true? After all of this conversation, which includes not only your votes on the charges, but a brief rationale for each of those votes, you write that together as a PJC. It isn't just the votes that are the action of the PJC, it's the decision in its entirety. And this is actually cases have been overturned on this ground. So I really want to lift this up for you. The entire PJC has to together approve the written decision. And you are not done with your deliberations until you have approved the text of that decision together. If it doesn't include rationale, you can read several cases over the last few years where the GAPJC has said, with increasing directness, if you don't include rationale, we are going to assume that there is not sufficient basis to your decision. You need to at least give an explanation to the parties. And it's not just because of appeals. It's not just because the GAPJC wants it. It's what's fair. These people went all the way through this process. Sometimes it takes years to reach a trial. You're making a decision that affects people's lives. The least you can do is give a little bit of explanation for why you decided what you did. So it is required. It doesn't have to be pages and pages. It could be that we heard all the evidence and we don't think they did it. But you need to explain why you have voted yes or no on the charges. Once it is agreed, once you have voted, once you've all agreed, you've voted on the decision as a whole, this moderator and clerk can sign that decision, and and this is a disciplinary case we're talking about. So you reconvene the open court. The moderator announces the verdict on each charge in an open meeting. Now, and then you begin the censure phase. This is a disciplinary case. So if any finding includes a finding of guilt, then you have a little more work to do. The evidence is presented first by the prosecuting committee on the extent of injury, as well as, and whatever else the prosecuting committee wants to submit. There is an opportunity for the accused to present evidence of rehabilitation or redemption. Both parties may present evidence as well, interestingly, as the original accuser. The PJC can invite the accuser, who is not a party to the case otherwise, to present evidence at the censure phase of the trial. And as of a couple of years ago, there's been a sentence added to this paragraph that specifically says the person who was directly harmed by the offense can submit what is called a victim impact statement that is not subject to cross-examination. So that's not in the earlier part of the trial. This is after guilt has been determined. But once the PJC has said, yes, we find the defendant guilty, the accused guilty of these charges, then the victim impact statement can be introduced, and it's not subject to cross-examination. Just to make a distinction, the person directly harmed by the offense is not necessarily the accuser. The accuser is the person who filed the written statement alleging an offense, and that person has to be a member of the Presbyterian Church USA. But they might have gotten their information to file that allegation from someone else, possibly someone who's not Presbyterian but was the victim of abuse or some other offense. So that's the person here who's directly harmed by the offense. And that's it. So there's now, in addition to the parties, the prosecuting committee and the accused, we now have introduced two other people, the accuser and the person harmed by the offense. Christiane. You're muted, Christiane.
Sorry, you said may be invited by the PJC. Is it necessary for the PJC to invite the accuser to make a statement?
The accuser is not required to be heard from, but they can be heard from. The victim, the person who was harmed, the victim impact statement must be allowed. They may submit one. Bruce. Bruce.
The victim impact statement then is an exercise precatory to handing down whatever verdict that you have, or whatever censure, I guess, that you're going to hand out? Or does it affect that?
I'm not sure I understand your question, Bruce. Can you try that again?
Well, the victim impact statement in a criminal case, I guess, has something to do with what the ultimate decision is, possibly.
You mean who the victim is? Figuring out?
Yeah.
Yeah, I mean, I appreciate that. There is actually, I'm not crazy about the language victim impact statement because it is out of the secular process, and it's the only place we use the word victim to describe this person in our process. We usually use the person who was directly harmed by the offense. So it introduces a little confusing secular word into our otherwise different process. But having said that, I think we understand what it means. And the victim impact statement is, as you say, has become something in a lot of criminal proceedings. I don't think there needs to be a lot of question about who the alleged victim is, or now the victim. But I think the PJC is fully empowered to make that determination. And of course, that decision is subject to appeal. So if they allow a person to speak who the accused doesn't think should have been allowed to speak, that can be part of the appeal that goes up to the next council. Gordon?
Who is to assure that the victim is invited to make that statement? Or the victim can choose not to make the statement, I assume.
Yeah, it doesn't say, but I would assume it's the prosecuting committee. They're the party that the Presbytery has entrusted throughout the process to engage with the people who are alleging harm. And it is part of their case for what a particular censure should be. So I would say that that's the prosecuting committee's responsibility, but I'm prepared to be challenged on that if there's reasons why that might not be the case.
Brian, this is Martha. I was involved in one of those, and that's exactly what happened. The complaint was filed by not filed by the victim, but then there was the victim impact statement that was, and I worked with this person on there to make sure it was relevant and focused and all that kind of stuff. I'm sorry, I was representing the prosecuting committee. So yeah, that's what happened. And a lot of that was in the back and forth as we dealt with where we were going and what we were going to do. So yeah, prosecuting committee did that.
Great, thank you. After you've received that evidence as a PJC, again, you go back to private deliberations. I'm not spending a lot of time today talking about the elements of the censure, but I would encourage you to be particularly attentive to that section of the rules of discipline, because a lot of PJCs don't follow them exactly, and it has led to negative outcomes. There are very specific categories of censure. In particular, I'd encourage parties and PJCs, if their censure of choice is involves temporary exclusion with supervised rehabilitation. Supervised rehabilitation is this catch-all term that can mean everything from counseling to becoming more repentant to just allowing time to pass. But there needs to be clarity about who is responsible for determining whether the milestones and landmarks that are set out in that process have actually been achieved. And if it isn't, because the one group that it can never be is the PJC. Once the PJC makes its decision, you're done with the case. You're not responsible for ongoing enforcement. So the Presbytery needs to have clarity about who is making the assessment that a person's rehabilitation is complete. And what I would suggest is that when it says may require a period of time or certain things to be accomplished, you should take that "or" seriously. And if you're going to make it about time, make it about time. If you're going to make it about things that have to happen, they should be clearly measurable with a clearly identified person who's making that assessment, a group of people. And the Presbytery then is compelled to restore the person to ministry when those things happen. The more ambiguity, the more likelihood that there's going to be another case down the road challenging how the Presbytery implemented your decision. David?
Right. Hey, thank you for that comment. Certainly resonates with me. One of the challenges always, and any kind of a determination, is making sure that a judgment or ruling of a court or a church council is actually administrable. We have, as you said, clearly defined milestones. So I'm curious from the panelists and also Brian, from your perspective, is this where we might helpfully utilize the role of, say, a personnel committee from the session of the church, of the individual involved, the accused who's now been found guilty, and ask for, that personnel committee to monitor the progress of some type of a rehabilitation plan, etc.
I think you could go a lot of directions, and probably the prosecuting committee is in a position to make a recommendation for what directions you go. It'll obviously be up to you what you want to choose to impose. One thing I would suggest is that if there is going to be a group that makes a determination whether that work is complete, it should be a group that represents the Presbytery or is accountable to the Presbytery. So maybe the decision is to require a certain period of reflection and discernment in conversation with the church personnel committee, but it still should probably be maybe a task force of COM or the COM itself that is responsible for assessing whether that has been completed and whether the congregation had the resources to do that, if that makes sense. But yes, I think there's a lot of latitude in what you can impose in a censure, but if it's too wide, if it's too vague, then you're not really sure whether the censure has been fulfilled or not. There's a lot there. The temporary exclusion with supervised rehabilitation is a problematic censure in a lot of cases, because so often it's not clear when the censure is supposed to end, and the PJC can't come back together and explain. Becky?
Yeah, I appreciate the statement about accountability. And what about if, in the case of a PJC making a decision and designating a committee of the Presbytery to be the ones accountable for following up on the decision, and a congregation writing a letter protesting the decision, should that letter of protest should that be directed to the PJC at that point? And if it is by the Presbytery for whatever reason, should the PJC take it up or say, we have, we've made our decision, we've designated who's to carry through with it, we are now finished?
Yeah, I don't think there's any standing for that submission to go to the PJC.
Okay.
I would probably, if I sent it to the PJC at all, I would clarify that this is only for their information, but they are not expected or even permitted to do anything in response to it.
That seems right to me, and I like that. I needed the language. They're not expected nor really permitted, because it felt out of bounds at the time.
I guess I'm questioning whether I'd even send it at all, but I think people can be grown-ups, so I probably would send it. I wouldn't think I have to protect them from it, but it's not, there's nothing to do after the decision has been made. Right. If the congregation objects, that their objection is not relevant to the judicial process.
Okay. Thank you.
Yeah, sorry to the congregation in question. Stages of this process here, after the censure is decided, the moderator comes back, the whole PJC comes back, announces the censure in open court, and that's where it is actually pronounced. So there's language in the Book of Order about how you pronounce a rebuke or an exclusion from office, and the moderator actually speaks it to the accused, now the guilty person, right there on the spot, and that is it. That is the end of the process. If they have been removed from ordained office by your action, that is the moment at which they are removed. No further action by the Presbytery. Stated clerk writes it down. And I will say that I said that one of the very serious things for me is hearing those words at the beginning of the trial. The other felt like the most serious thing I've done in ministry maybe was when I was the moderator of the Presbytery PJC and pronounced a censure with a colleague who I knew, declaring that she was now excluded temporarily from ordained office for a period of years. And it's a very sobering thing, a very serious responsibility, but also a great opportunity for grace, and for healing, and for a moment for the church to really feel like the church. It is this moment of authenticity and honesty. We're together in something hard, and you'll notice that it is to be followed, all of the censures are to be followed by intercessory prayer. You pronounce the censure, and immediately the first thing you do is pray. Becky?
And that it's clear to me that open meeting is an open meeting of the PJC.
Yes, not the Presbytery, the PJC.
And is it then read at a Presbytery meeting? Oh, here we go.
In fact, it is.
Okay.
And unlike a remedial case, which we'll talk about tomorrow, a disciplinary case, the decision is actually read by the stated clerk at the meeting. There's some unclarity about how much of the decision you have to read. Do you have to read it from start to finish, every page? That's not entirely clear, but it seems clear that you need to read the charges, the findings of guilt or not guilty, and the censure that's imposed. There's no hiding it. There's no brushing it under the rug. It is because it is an act of that body that the commission has taken on its behalf. David.
So without divulging any names, very curious. So in that instance that you just cited, and again, in an attempt to bring this from the realm of the hypothetical, where the rubber meets the road, what was the offense the accused was found guilty of, and how long was the removal from the practice of ordained ministry?
It was consensual sexual misconduct that involved a misuse of office.
Mm-hmm.
I can't remember how many years exactly. It may have been 3. It was significant, but it was not career. I say it wasn't career ending. It was career ending for that particular ministry, because one of the consequences of a temporary exclusion from ordained office is that any ministerial functions have to stop. So any pastoral calls are effectively immediately dissolved by a temporary exclusion from ordained office. You're not just taking a 6-month break and returning to your church. The call is dissolved with a temporary exclusion, because you can't be installed to a position when you can't function as minister. In that case, they were not an installed ministry. They were in a validated ministry from which they had actually already been fired. And for the rest of their career, they will do other things. Becky?
Could you speak to the manner in which the stated clerk shall read the discussion to the presbytery? Any guidelines that you think are?
Well, I don't think you should use a funny accent. I'm sorry, I don't know why I just thought of it.
I know.
In the manner of a British gentleman. No, that's not how you should do it. I'm sorry, I'm feeling very silly all of a sudden. I take that back. There's nothing serious, nothing silly about this. Like I said, it's not entirely clear that you have to read the entire decision. But my take is that it would be part of your stated clerk's report to the presbytery. You know, for me, my stated clerk report is usually in writing for the most part, but sometimes I will be highlighting a particular piece of it. In this case, I do, in fact, I would say you do actually have to stand there and say it. There is no requirement that the person who has been found guilty has to be present for that meeting. Maybe that's part of their act of repentance and healing, but they certainly don't have to be. Obviously, if they've been excluded or removed from office, they are no longer a member of that body, or if they're temporarily excluded, they can't vote at presbytery during that period. So yeah, there's no prescription for how it would be. My suggestion would gracious a way as possible, while honoring the fact that naming the guilt is part of why we do it. It's an exercise in holding up for the church our commitment to truth and transparency and honesty about brokenness and the ways that the church responds to brokenness.
Good, thank you.
Yeah. Just to put a bow on this, the last couple things that happened, the moderator and clerk signed the decision. The clerk of the PJC files it with the stated clerk. It is the stated clerk's job usually to do this, but technically it is the responsibility of the PJC clerk to make sure it is done, that it goes to the stated clerk sends it to the parties, as well as takes care of this reporting to Presbytery. The last responsibility in the trial for the clerk of the PJC is to put together the record of the case, finish those minutes, note what evidence was received and what was admitted, and transmit it all to the stated clerk within 14 days. That's important because the stated clerk might have to take that material and send it as the record to the next higher council should that decision be appealed. Remember, in a disciplinary case, only a guilty verdict may be appealed. The person who's been found guilty can appeal that finding, but the council, if the person is found not guilty, the prosecuting committee cannot appeal that decision. That would be double jeopardy. Finally, it's the council's job to enforce the decision, not the PJC. Your work ends at the end of the trial and the decision. There's no provision for you to be the ones who make sure that the accused has followed some sort of requirements that you set out. It's up to the presbytery to enforce what you have said. I'm seeing some comments. These are mostly people saying they have to step out. Thank you for being here. We'll see you tomorrow morning, when we will pick up a conversation about remedial cases and the PJC. Also on tomorrow's agenda, we'll be taking a look at, I don't know, you saw the schedule. I don't even remember, but it's 5 o'clock anyway. Are there any last minute questions? We will start at 9 a.m. It's the same link.
Ernie has a question.
Ernie has a question. Ernie.
He has to unmute himself.
And if this takes too long, you can defer. This is about the victim impact statement. Does that victim have to be someone who has been identified in the course of the trial, either by name or by situation? Or can it be someone for some unrelated prior bad act that would just reflect on the character of the accused?
Like I said, this is a fairly new provision, and there's not anything besides what's printed there in the Book of Order. But I would certainly, my interpretation would certainly be that we're clearly talking about the victim of the offense that was dealt with in the trial, not previous victims who have not come up before or about whom nothing has been proved in this proceeding. So just a quick word about what our plans are for this morning. We are going to pick up where we left off. Yesterday, we talked about the PJC and disciplinary proceedings. Today, we're going to talk about the PJC and remedial cases. Some of it's the same and some of it is different. After that, we'll talk about appeals. I know some of you represent Presbytery PJCs and others are on the Synod PJC. I think everything we talk about today will be relevant to all of you. The case of remedial cases, usually when a Presbytery PJC has a remedial case, it's against a session, but you will be so that doesn't happen all that often, but it does happen and you need to be prepared for it. The Synod PJC almost always deals with remedial cases, not disciplinary ones. And those are usually against presbyteries. When we get onto the appeals, Presbytery PJCs don't get too many appeals. You, in theory, could get an appeal from a session decision on a disciplinary case. But you need to know how appeals work because your decisions are almost always reviewed by the Synod PJC on an appeal. So it's good to know how that works. In the case of the Synod, almost everything you do is appellate, certainly around after presbytery decisions. And so you'll want to know those things too, not to mention the fact that your decisions can be appealed to the General Assembly per PJC. It's good to know how that works. After we talk about appeals, we'll take a little break this morning, and then I'm going to introduce you to a few resources that are available to you. I'm going to show you some sample decisions to give you a sense of how a decision might be drafted. There's a pretty clear template you can follow. You don't have to make this whole thing up from scratch each time. And also, I'm going to show you the annotated book of order online. If that's a resource you've never used before, it's very powerful and very helpful in doing the work of discernment in a judicial context. All right, any questions? Are you ready to go? Very good. Let's get started. Remedial cases and the PJC, or can't we all just get along? The fact is, and I've said this before, maybe even to some of you, I think 95% of our situations in the church when we are in conflict with one another, maybe 98% of them, would be better resolved through, well, going out for a beer or the beverage of your choice, not through judicial process. But when a conflict is intractable, or where there's an honest disagreement about what is proper that needs to be resolved in a way that carries the imprimatur of the larger church, judicial process can be a really helpful way of getting to that conclusion. So let's talk about just a reminder of some of what goes into to a remedial case. What are the basics of remedial cases in the Presbyterian Church? First of all, a remedial case begins with a complaint. That's the official name for it, not just a whiny church member, but an actual filing of a complaint that is filed by someone who has standing to file it. In the case of a complaint against a session, it can be a member of the congregation or a member of that session, or it could be another session in the same presbytery. In the case of a presbytery, a complaint can be filed by a session, or by a minister member of the presbytery, or by any ruling elder who was a commissioner or an elected member of that presbytery at the time the allegedly irregular decision or omission occurred. This is all spelled out in the section on remedial cases in the Book of Order. One of the first decisions a PJC makes is whether the complainant has standing to file the case. At the time they file a complaint, they can also request a stay of enforcement. Now, a stay of enforcement we're going to talk about in great detail in just a few minutes, but essentially that's requesting the PJC to put a pause on the action until the judicial review process is complete. As soon as that complaint is received, and the respondent, which is what we call the person on the other side in a remedial case, or not the person, rather, the counsel, the respondent files an answer to that complaint. So the first thing that happens is two written documents, a complaint and the answer to the complaint. Those are taken together and sent to the moderator and clerk of the PJC. So here's one of those times where who you choose as moderator and clerk really matters, because they have a very important gatekeeping, sort of a threshold decision to make here. They'll decide the preliminary questions and either accept the case for a hearing and trial, or hearing or a decision, or they'll dismiss the case. Now, those findings can be challenged by either party, and so often the question of whether to accept or dismiss the case ends up being decided by the full PJC anyway. The PJC will meet, and once the case is accepted, a pretrial hearing is held. This is a proceeding that is intended to encourage the parties to come together, see what it is they agree on, see if they can agree to a stipulated set of facts, try to narrow the scope of the dispute. Sometimes the complaint is really messy. One of the realities is that this is a church process, not a legal process, right? So not every document that is filed is by a lawyer, or even if it is by a lawyer, it's not always in perfect clarity and order. What we are trying to do is get to the place so that when the PJC holds an actual trial, what is being discussed, what is being decided is very clear. So if I am running a pretrial conference, I will try to narrow the conversation to kind of what are the key questions we are deciding. Ideally, the questions you're deciding line up with the points in the complaint, but sometimes it involves consolidating the points in the complaint or sort of reorganizing them for the purpose of clarity. You hold a trial. We'll talk about how that works. You deliberate, you decide, and at the end, you publish a decision along with your orders, which are reported to the next meeting of the council. And the PJC has the full power of the council that elected you to direct, to order lower councils to take certain actions. So you could reverse the decision of a session if you're the Presbytery PJC. If you're the Synod PJC, you could reverse the decision of a presbytery or in fact, order them to do something else. You could also, as the Synod PJC, remand the case for further proceedings in the Presbytery PJC. If the PJC dismisses a case, for example, and that gets appealed to the Synod could say, you shouldn't have dismissed the case. Now you need to go back and have a trial. We'll get to all of those possible outcomes here in a little bit. So let's walk through the steps of this overview. First of all, let's talk about those preliminary questions. This is an area that is probably one of the most difficult to understand, but it's part of every case. In order to be accepted, a remedial complaint has to meet 4 threshold questions. And then we call those the preliminary questions. The questions are jurisdiction, standing, timeliness, and whether the complaint whether the complaint states a claim upon which relief can be granted. The first 3, I think, are fairly self-explanatory. Jurisdiction is the question of whether this PJC is the right one to hear this case. So if you get a complaint at your Presbytery PJC that says, I don't like something that the Presbytery did at its last meeting. That might sound like the kind of thing you take the Presbytery to court for, but you don't take the Presbytery to the Presbytery PJC. You take it to the Synod. And so the Presbytery PJC should dismiss that case on the grounds of jurisdiction. It doesn't have the jurisdiction to do that. Second one is standing. This is back to who can file a case. It's all very clearly laid out in the Book of Order. So this is something the moderator and clerk should be able to determine. Timeliness has to do with deadlines. There are a number of deadlines laid out in the Book of Order. For example, in the case of an irregularity committed by a council, if you think they've done something improper, you have 90 days from the date that the council took that action to file a remedial complaint. On the 91st day, that complaint is no longer timely. You'd be surprised how often this is actually in dispute when a complaint occurred, which is why sometimes the hearings to resolve preliminary questions are evidentiary hearings. When did an action actually occur? And part of what's complicating this these days is that a lot of presbyteries and a lot of synods delegate actions to commissions of the presbytery or the synod. And one of the things, as you can read through past decisions and explore the development of this practice, we understand that when a commission is empowered to act on behalf of the council itself, the action of the commission is the action of the council at the moment it takes it. So if you have a commission on ministry in your presbytery that has been empowered to do certain things, like receive ministers into membership or dissolve, if you've authorized them to call a congregational meeting. When the commission does that, they are acting as the presbytery. And what we have said is that that's when the 90-day clock starts for filing a remedial complaint. Now, just in the last meeting of the General Assembly PJC, we had a case, John versus Presbytery of New York City, where we examined the problem that a commission can take an action that nobody knows about, because unlike a presbytery meeting, it's not generally advertised. You don't know when it occurred. You sometimes don't know it occurred until it's reported to the next presbytery meeting, and that's if they report it. So the PJC addressed that and clarified what the 90-day timeline means in that situation. But all this to say, when resolving the timeliness question, you're trying to figure out when the action occurred and whether the complaint is timely. The fourth one is actually the stickiest wicket. Does a complaint state a claim upon which relief can be granted. Now, I'm going to show you in the annotated Book of Order later this morning how many GA PJC cases have been about this one line in the Book of Order. An astonishing percentage of them. A lot of Presbytery and Synod PJCs dismiss cases on this ground. Frequently, those dismissals have been reversed. Here's what has to be true for a complaint to be accepted. The complaint has to state a claim. That is, it has to name something that actually, had it occurred, it would be improper, would be irregular. And it has to be a claim upon which relief can be granted. That is to say, there has to be something that the Synod or Presbytery PJC could do about it in order for this to make sense to proceed with a case. Examples. I've now done several of these, but I think this was with the stated clerks. I used this example yesterday. We had a case where members of a congregation objected to the dissolution of the pastoral call. But they didn't have standing to challenge the presbytery's dissolution of the call. They only had standing to challenge the session. And the only thing the session had done is call a congregational meeting to act on the pastor's request to concur with the presbytery's decision to dissolve the call. So they charged they filed an allegation, they filed a claim against the session. As that went through the process, the relief that they said they were seeking was to have the decision to dissolve the pastoral call reversed. But by this time, the pastor, in fact, had left. The pastor was serving another church. The pastor did not actually want the decision reversed. And so there were a number of problems with that complaint, but one of the reasons it was dismissed is because it didn't state a claim on which relief could be granted. There was nothing that the Synod PJC could do or the Presbytery PJC could do to restore that pastoral relationship. They couldn't order the pastor to go back. And so that was one of the reasons that complaint was properly dismissed. There is a category of relief, however, that is available. And at times, the General Assembly PJC has upheld that this is a legitimate form of relief. And that's declaratory relief. That is simply a proclamation, a declaration by the higher council that what occurred in the lower council should not have, and it shouldn't happen again. And that is a form of relief because it preserves the peace and unity and purity of the church. It makes the church better for next time. This is in order for declaratory relief to be legitimate, it has to actually be a clear violation, a clear departure from the Constitution where such a declaration would be helpful. But it is possible that you can have a claim that states to which relief can be granted, even though it's not an actual reversal of the decision that was made. I'm going to pause here to see if there are questions. There are almost certainly questions that would require the next 3 hours just to answer. But this is a very common area for PJCs to end up down a rabbit hole and have to deal with. All right, we'll come back later as we talk more about this, I'm sure. If those 4 questions are answered in the affirmative, the case goes forward. If any one of them is answered in the negative, the case is dismissed. And if it's dismissed by the moderator and clerk and nobody challenges their ruling, that can be challenged either by a party or by any other member of the PJC. If it is challenged, there's a hearing. But if it isn't challenged, that dismissal is final. And the full PJC never even hears the case. Only those 2 members are involved. let's say that the complaint came with a request for a stay of enforcement. There are two ways that a complainant can request a stay of enforcement. One is if the council that made the decision, 1/3 of its members sign on to a stay. So if you have a very acrimonious presbytery meeting and there's a 60-40 vote to do something controversial, out of those 40% no voters, if 1/3 of those who were present will sign a stay of enforcement and submit it to the Synod stated clerk, the Synod stated clerk passes that along to the PJC, and they impose the stay of enforcement. That has to be accompanied by a complaint. That has to trigger a judicial process. The stay doesn't just happen on its own. It's part of the judicial process, and it lasts only as long as the judicial process lasts. But the other way to get a stay of enforcement, and this is where you as PJC members need to know about this, is it can be requested from the PJC. And if 1/3 of the members of a PJC sign on to a stay of enforcement, it takes effect immediately and lasts until the end of the judicial process. So those unhappy presbytery members file their complaint, they include a request for a stay. The stated clerk distributes that stay after the moderator and clerk have agreed that the case is accepted, distributes it to all of the members of the PJC, who individually decide whether they would grant the stay. This is the only time individual PJC members take action without doing it collaboratively, without deliberating and making a decision together. I think there's a difference of opinion among stated clerks about whether they're allowed to talk to each other about it, but clearly they are not required to. It's an individual assessment. And at the end of the day, the ones who sign the statement are doing that in their own name, not in the name of the full commission. So if you get one of these, you're on the PJC, what should you do? When should you sign a stay of enforcement? Well, the criteria are laid out for you in the Book of Order. It says what you are signing is a statement that in his or her judgment, substantial harm will occur if the action or decision is not stayed, and that in her or his judgment, probable grounds exist for finding the decision or action erroneous. So in other words, do you think that that complaint's going to prevail? They're asking you to prejudge the case before you've had a trial. Do you think it will win? And do you think harm will result if you don't put a stop to what's happening right now? And if 1/3 of the PJC members do think that, then the act is stayed. From the time you get the request for a stay of enforcement, you get 10 days to decide. After 10 days, the stay cannot be imposed and the judicial process just goes forward without it. But the action itself remains in effect. There is a procedure for the respondent to object after the stay is imposed. And at that point, you hold a hearing on whether to keep the stay of enforcement in place. Any questions about stays of enforcement? I see Mary Mitchell, Michael has her hand up.
Totally out of the judicial realm here. What's an example of when this would happen?
An example of when this would happen, so in my own presbytery, the presbytery took an action to form an administrative commission and assume original jurisdiction over a session. The session did not like that. And so a ruling elder commissioner to that presbytery meeting filed a complaint alleging that that was an irregular action and a request for a stay of enforcement. And if the stay of enforcement had been imposed by the Synod PJC, that administrative commission could not have been formed. It would have had to wait until the judicial process played out. As it turns out, the Synod PJC did not grant that stay. The AC did form and continued to work even as the judicial process was playing out, challenging its formation. Interestingly enough, in that case, the AC actually finished its work about 6 months later, before the Synod PJC case even went to trial. So they withdrew the complaint because the AC's work was done. Any other questions? All right. Valerie has a question.
So, but theoretically, if they hadn't withdrawn that complaint, the complaint could have continued asking for declaratory relief to say what you did wrong, don't do it again.
In theory, they could have asked for that. I think that would probably not be a great example of a case where that's appropriate, because it's not really in dispute that a presbytery can form an administrative commission and assume original jurisdiction. And the nature of their complaints were that the presbytery had sort of treated them badly, or not told, the COM had not told the truth in how it presented the situation. Those would not be such, those were more sort of evidence-based arguments that wouldn't have, they weren't like pressing constitutional questions that a ruling was necessary.
Okay, that's helpful.
But they could have asked for it, and it wouldn't have surprised me, but that's another story. Other questions? All right, well, let's move on. There's a question in the chat earlier from David. Can you email the participants the overview from the disciplinary process and today's overview? Yes. My plan is to email everybody the entire PowerPoint presentations along with a few of these other items that we'll talk about, these resources. So thanks for asking. All right. Before you go to trial, there's a few things that happen in a remedial case. And some of this will seem familiar from the disciplinary cases, but it is somewhat different. First, there's a hearing to determine the challenges to the officer's findings. So, like I said, the moderator and clerk make this ruling, but it is very frequently challenged by the side that didn't prevail. Go figure. And so the full PJC gets to decide those 4 preliminary questions. That pre-trial hearing on those kinds of questions has to happen ordinarily 30 days before the trial itself. But when circumstances dictate, according to the Book of Order, it is possible to hold that hearing just before the actual trial. And in fact, that's pretty common. Often the substance of the case has as much to do with that preliminary question debate over whether it states a claim on which relief can be granted as it does with the underlying facts. And so a lot of times a PJC will schedule that hearing for right before, but if the case is accepted, it then would need to be prepared to move right on to trial after that. PJC may also determine various motions. People can make a motion to dismiss on whatever grounds they want to try. There also might have been disputes over what evidence should be provided. The complainant, there is a process that I went over with the stated clerks about producing the record and submitting evidence. There may be a disagreement between the parties about what documents should have been provided and what is relevant. And so those are questions that have to be determined by the PJC sometimes. All the authenticated records of a body and minutes, those are all pretty standard. But what other documents are required? Does the notes that the COM moderator took on a phone call they had with the pastor of a church, do those have to be provided? Those kinds of questions need to be determined by the PJC. The record of the case does get prepared by the stated clerk and submitted to the stated clerk of the PJC's council. So the lower council, the respondent stated clerk, assembles the documents and sends them up to the PJC's council's stated clerk. In a pretrial conference, the PJC might then ask the parties to take all of that information and try to work this out. That's not out of line for the PJC moderator and clerk to sit down with the parties and say, what can you agree on? Is there a way to narrow this to just the things that are in dispute? Is there a different approach that would be better than resolving this through judicial process? But you do try to emerge from the pretrial conference with a clear picture of what the trial will be discussing. The other thing that happens before the trial that isn't on this list is that usually the PJC asks the sides to prepare briefs, written outlines of what they intend to present at trial. It's not required, but it's something that makes a lot of sense for the PJC to have a clearer understanding of the case ahead of time. When we move on, we get to the trial itself. This is a little bit different than a disciplinary case, but still includes a lot of the same materials. It does, I didn't put it on the screen, I should have. It actually does begin with the preamble and with the members of the body being enjoined to recollect their high character as judges in the Church of Jesus Christ. It begins with prayer. And then it proceeds, it does provide the opportunity for members, for either party to challenge the composition of the PJC. And then it moves to opening statements. The complainant makes the first statement, the respondent is second, and then you go on to presenting evidence. Now, one way that this sometimes is different than a disciplinary case, but not always, is that sometimes there is less need to present evidence and to call witnesses. You can have that, and it certainly depends on the nature of the complaint. If the complaint is about things that happened that shouldn't have, and there's dispute over whether those actually happened, then of course you're going to call witnesses, you're going to introduce documents as evidence, and those rules of evidence are the same as they were that we talked about yesterday. But there are times when the nature of the dispute is not really about the facts, it's about the law. It's that everyone agrees on what happened, and the debate is over whether it should have happened. Does that make sense? That's very common, especially in remedial complaints against a presbytery that are filed with the synod. The allegation is that the presbytery did something it wasn't supposed to do, and the presbytery's position is, we did do that, but we're perfectly right to do it. In those cases, hopefully in the pretrial conference, you can get the parties to agree to a stipulated set of facts so that all you have to do at the trial is have arguments. The counsel can speak to why it was or wasn't irregular, and you don't have to go through such a long trial. I see that's a little difficult to read on the screen in those colors, but when it's all over, you have closing arguments. The complainant has the right to speak last, and then you submit the case for deliberation. Are there questions about how a remedial trial goes? Valerie? No.
Yes. Well, yeah, I'd like to, can we talk about time?
Mm-hmm.
Is a moderator, a PJC moderator, able to put a time limit on, because quite frankly, some of these folks can talk forever. They can argue their case forever.
Can there be time limits? Absolutely. The PJC is fully empowered to conduct the trial however they see fit. The standard that the PJC has to meet is that it needs to be fair to both parties.
Mm-hmm.
So if you can't do anything, the way the trial is conducted is reviewable. It could be the basis of an appeal, but the PJC has wide latitude as long as it's fair to both parties. So in the case of the GA PJC, we have a set, those are usually appeals, not trials.
Right.
But even when we had an original jurisdiction trial, we said your opening arguments can be 20 minutes each. That you will then have, I think we said 4 hours to present your case, and you'll have 4 hours to present yours. That was a very complicated remedial case by a presbytery against a synod. But we set a time. My point is, as long as it's fair to both sides, you decide how much time you think it needs, give it to both sides, and you can do that. We had a hearing last year where we gave each party 10 minutes to make their argument. The entire hearing was 30 minutes. And that was enough because we knew the facts.
Right.
We didn't need much argument. So you are free to set those limits. And like anything else, I would suggest that the right way to set those limits is for the moderator to maybe the moderator and the clerk working together to develop a proposed procedure and then bring it to the full PJC and get the full PJC to agree. Other questions about trials? Okay. There's a question, will the recordings be available as well? The recordings are available to someone.
They will be.
Okay.
Yes, we put them on the website.
Yes. All right, so once a remedial case goes to deliberation, it is similar to the disciplinary process in the sense that deliberations are private and all the PJC members need to be there in the room till it's done. If they leave, they can't participate anymore, so you need to take breaks. And just as with the disciplinary case, you vote on every charge. In the case of a remedial case, you vote on every alleged irregularity or delinquency in the complaint. Sometimes you can get the parties to agree at your pretrial conference to sort of consolidate those allegations so that then you're deciding something with more clarity. But the presumption is that you vote on each of the alleged irregularities or delinquencies. What does it mean to vote yes, to sustain an alleged irregularity or delinquency? It means that you find proof by a preponderance of the evidence when weighed with that opposed, the evidence that when weighed with that opposed to it has more convincing force and the greater probability of truth. Notice that that's a different standard than in the disciplinary process. When to find someone guilty, you have to find the evidence shows it beyond a reasonable doubt. This standard is by a preponderance of the evidence. When you weigh the evidence for and the evidence against, which one comes out ahead? Not beyond reasonable doubt, but which has more? The vote on that is recorded in the minutes, and the majority rules. You don't need a 2/3 majority. A majority vote is necessary to sustain an irregularity. If the complaint is sustained, then you need to order the relief that you find appropriate. That might be simply to reverse the Presbytery's decision, to declare it null and void. It might be to remand the case back to the lower PJC for further proceedings. And I think we could probably imagine there have been a few more heavy-handed sort of orders levied that sort of say, and the lower PJC needs to get some training, or some things along those lines. But for the most part, it deals with the action that was taken and how it needs to be modified in order to be constitutional, or how it needs to be reversed because it wasn't constitutional. Any questions? John.
Yeah, thanks. And I'm sorry, I'm pull us backwards a little bit. This came up from what you said just before you got to what you just covered. But so you said the PJC moderator could propose times for testimony in the trial, and then the entire PJC would weigh in on that. So that's a time when the PJC would gather. Is this a moments before the trial situation or days before, so they can inform the parties ahead of time, or how does that work?
Probably days before. I think you want to tell the parties ahead of time what the procedure is. I think you can do this a number of ways. I think you could say that the moderator needs to propose it to the PJC and then they announce it. You could also say that the moderator declares this is what it will be, and the PJC has the opportunity to object. I think a lot of the system places a lot of trust in the moderator to give leadership to this part of the process. technically, it's all subject to review by the full PJC. I would hope that's not I would hope the moderator, if they're not sure it's the right direction, would be proactive in seeking the views of the PJC before they do it.
Okay, and just for the sake of efficiency, are there any other kinds of pre-trial, all PJC decisions that should be kind of bunched up into the same time that they gather for that purpose?
Yeah, so usually for a PJC trial, the trial occurs within the context of a PJC meeting. You know, you're going to gather, you're going to talk about the case a little bit, you're going to make sure everyone's got the briefs, you talk about what the process will be, say who's going to do the prayer and who's going to do this. So, you know, I would not count on people just showing up and starting a trial. I'd say the PJC needs to talk a little before it starts about how it's going to go.
Mm-hmm.
The other reality is that since most Presbytery PJCs don't have a lot of trials, or Synod PJCs, some of these things might very well be incorporated into a manual that you adopt and then follow. I talked about this with most of your stated clerks yesterday, including you, John. And the reality is that having a manual is a real benefit to these members of PJCs who, most of you, don't do this. This is not your full-time gig, and you may not do it in 3 years and then suddenly you have a case. Having a manual as a guide could be really helpful. So if you're looking for something to do in all those years when you're not having cases, maybe a good thing would be to have a couple meetings and approve a manual for your PJC.
Thank you.
Martha.
Yes, you've said a number of times that the PJC goes into deliberations, and the Book of Order says all persons not members shall be excluded, but it doesn't say, and nobody can go to the bathroom while in session. So is this someplace else where it says they must continue and nobody can leave? Or is that just practice? I mean, it's good practice. I'm not arguing with that.
Here's what it says at D110304. That's in the disciplinary section. There's a similar paragraph in the remedial one. D110304B. The absence of any member of the session or permanent judicial commission after a trial has commenced shall be recorded. That person shall not thereafter participate in the case.
Okay. This is back to all this stuff needs to be in the same place. Yeah.
Exactly. 100% agree, Martha.
Yeah.
So, and yes, it is interpreted in practice probably as strictly as you could possibly read that paragraph, but it makes sense also. That if the decision is truly the decision of the full body, you can't be sort of making advances in the logic and thinking of the group while some of the group isn't there. I think I can imagine, it's not impossible for me to imagine that people might be strategic about when they say certain things based on who's in the room, if that were allowed to occur.
Mm-hmm.
Brian.
Thank you.
Thanks.
Brian, this may sound simplistic, but can you recess to go to the bathroom and
Yes.
not talk about it?
Yes. I mean, this is one of the things stated clerks should probably help with, reminding the moderator. That's one of the few ways a stated clerk should insert themselves into a trial or a deliberation, reminding the moderator that maybe you need to take a break. I would suggest that the moderator should have a very lenient attitude toward members requesting a brief recess.
Thank you.
Yes, yes, it depends on the endurance of the moderator, whether that'll be a challenge. Others? Becky.
Well, and I heard a little PS to that last comment by a participant, and so the moderator might properly instruct folks at each break, don't discuss this while we're breaking.
Yeah, if that is deemed helpful, that is correct. They should not, there's not private deliberations. The only thing that there can be, and I offer this advisedly because I think it needs to be part of the culture and practice of your group. But in the case of the General Assembly Permanent Judicial Commission, which is often dealing with several cases at one time, the practice of the body is to elect a case committee, a small group who does more in-depth constitutional research on a case, and sometimes is the group that conducts the pretrial conference on the case with the parties, and then presents to the PJC the broad picture of the case, the background, as a way of preparing them for an appellate hearing. And then that same case committee is the group that after the deliberations, they are empowered to go off for a little while and draft parts of the decision. But they're not drafting a recommendation to the commission for them to just sign off on. They are helping equip the commission for deliberations, and then taking what they hear in the deliberations and trying to help avoiding a wordsmithing an entire document with 16 people from scratch. And so that sort of process is acceptable, but only because it operates under very careful constraints. And people who aren't on the case committee are still not empowered to just go off to the bathrooms and talk about the case. Thanks, Becky. I don't think most commissions need that kind of setup for most cases, but it perhaps in certain situations. Okay, so that's remedial cases. Now we're going to talk about how appealing works. Again, I think this is relevant even if you're on the Presbytery PJC and you're not going to have that many appeals. You need to know what might cause appeals of your decisions to be successful. And so we're going to talk a little bit about that process. Are we okay? Do we need to take a little break, or are we okay to press ahead? Is anyone? I'm going to try to be that sensitive moderator who does not cause a mistrial by allowing you to leave. All right, then we'll press on, but we can stop here in a little bit. Here's the basic understanding of how appeals work. And maybe I should even be more basic than what's on the screen. In our system, what I'm calling in these slides the higher council and the lower council, that is probably not the best term. Sometimes we try to use the words the most inclusive council and the less inclusive, but I think just for clarity, what I mean is the General Assembly is the highest council, then the Synod, then the Presbytery, then sessions. In our process, those councils always have the right and the responsibility to review one another. They do that through administrative review, things like reviewing the minutes of the lower councils. They do that through special administrative review, like appointing administrative commissions sometimes to work with lower councils. But they also do it through judicial review. And just like in the federal court system, where you have district courts and then you have circuit courts of appeals, and then you finally have the Supreme Court of the United States, we also use that same sort of appellate judicial review process. Decisions of the Presbytery PJC can be appealed to the Synod PJC, and those decisions can be appealed to the General Assembly PJC. Just a word about vocabulary to start. The party that's appealing a decision is known in our process as the appellant. Then the party that is having the decision that prevailed in the lower PJC and now is defending it, that is opposed to the appeal, is the appellee. Notice that it is the responsibility of the prevailing party, not of the PJC itself, to defend the PJC's decision. And this is sometimes a complicated matter, because sometimes the PJC has done something that's really not very defensible, but it's the job of the party that prevailed to defend it anyway, so that they still remain prevailing in the case. The PJC, the lower PJC, has no further activity in this process once their decision is rendered. It's up to the parties. The appeal, of course, is a review of the proceedings and the decision by the lower PJC. It is not a retrial of the original underlying case. The higher PJCs show deference to the findings of fact that are made by a lower PJC. What they review are the processes and the proceedings and the constitutional interpretations that that PJC made, and to determine whether there was an error in how they proceeded. It's unusual for an appeal to include the introduction of evidence, although there is a provision in the Book of Order for if there is some newly discovered evidence that has emerged since the trial, since the lower decision, and under certain circumstances, the higher PJC might receive that evidence, but doesn't necessarily have to. Appellants, just like in a remedial complaint, appellants can request a stay of enforcement. And it's in the same way as they would with a remedial complaint, including having 1/3 of the members of the lower PJC sign the stay of enforcement. So if the PJC at the Presbytery is bitterly divided, enough that 1/3 of them say this decision should not take effect, they can effectively stay the enforcement of their own decision until the Synod has a chance to review it. And then finally, what happens if any specification of error is sustained? Then the lower PJC decision, there's a number of things that can happen with it. It can be affirmed, it can be set aside, it can be reversed, or the case can be remanded for a new trial. That's one of the decisions that the higher PJC needs to make is, okay, we think they screwed up, but what does that mean? Do we think that requires a new trial? Do we think the case is now moot? Do we actually want to just say they should have made the opposite decision and we hereby declare that? Christiane.
I'm a member of the Synod PJC. If we were to receive an appeal of a case involving my home presbytery, would I automatically have to recuse myself?
Excellent question. And the answer is yes. Members of any council that is a party or that is the immediate subject that is itself accountable to the council that is a party has to be recused. So that means that at the Synod level, if you are from the same presbytery as the presbytery that made the decision, you're going to have to recuse yourself. Mary.
I have two questions just in the terminology. Well, set aside, what does that mean?
Yeah, the term set aside, so these terms are in the Book of Order: affirmed, set aside. Actually, there's one that's not there: modified, reversed, or remanded. They're in the Book of Order and they're not defined. I take set aside to mean that decision, we're not reversing it. We're saying that but we are saying that it no longer applies. It could be that you think that the proceeding was addressing the wrong questions or something. I don't know exactly what the circumstance might be. I'm trying to think of a time I've ever seen that term used. But I guess I would take it to mean stopping short of reversing the decision, saying they got it wrong, but rather saying it needs to go a different direction, I guess. Maybe someone else has more insight into that, but I think it doesn't mean anything more. it doesn't have some magical legal meaning that I know of other than what those words just mean. Mary?
If it's remanded for a new trial, it goes back to the same PJC?
Yes, so this would be, I think, usually a case where they dismissed the case and the Presbytery PJC dismissed the case for failure to state a claim on which relief can be granted. That gets appealed to the Synod PJC, which says, no, you shouldn't have dismissed the case, and we're remanding this for, we are deciding that the questions should be answered in the affirmative, and you need to proceed to trial. I suppose you could say that they might remand a case for a new trial if a member of the PJC should have recused themselves and didn't. And rather than reversing their decision, the Synod PJC says, you need to do it again without that person involved. I don't know why they would do that, but that could be something they could do. Thanks, Mary. Bernie?
When a matter is being appealed, the prevailing party is the one that has to defend the decision of the PJC. In that circumstance, to what extent can that PJC or the stated clerk for that council assist the prevailing party in defending what they did?
I would argue that that would not be appropriate. Anyone else? Becky.
I have a question about the terminology as well. Just if you wouldn't mind helping me understand on your last bullet point, if any specifications of error with the lower PJC decision are sustained, which sounds to me like an error is found, then the lower PJC decision may be affirmed. That seems contradictory. Maybe I think I'm misunderstanding something.
No, you're absolutely correct. It does seem contradictory. Affirmed is one of the options. So if you look at that whole section, it says if none of the specifications of error are sustained, then the decision is affirmed.
I see. Okay.
If any of them are sustained, it may be affirmed or set aside or reversed or the case remanded. So I think what does sometimes happen is that they name 5 specifications of error. The PJC does not sustain 4 of them. They do sustain 1 of them, but they say that it didn't really affect the outcome of the case. That even though that was an error, the Synod, the lower PJC still made the right decision. And so they affirm the decision, even though they have specified one of the errors was sustained.
Thank you.
All that, I think the point there is that just because a PJC makes a mistake doesn't mean their decision has to be reversed. You still act in the cause of justice. You still do the thing that is right in the biggest picture. Let's see here. Gordon.
Who determines who the appellees are going to be?
Well, the appellee is pretty automatically the other party, the prevailing party. Because if the appeal is sustained, then they will no longer prevail. So they're the ones who have to defend that lower court decision.
But I assume those people are from the Presbytery. I mean, who would determine who represents the Presbytery?
Thank you. So anytime a complaint is received against a council, the first thing the council does, or for that matter, anytime a council files a complaint, the first thing the council does is appoint a committee of council. And the Presbytery usually provides by rule for how a committee of council gets appointed. But it's 3 people, cannot include the stated clerk, who are responsible from that point forward for representing the council throughout the case. So that includes not only preparing for a trial, actually litigating the trial, but it also includes making decisions about whether to appeal or defending through the appeal. That committee of counsel sees the case through to the end on behalf of the presbytery or whichever the council is.
Could those three people include someone from the PJC, the lower PJC?
No. PJC members. So again, the PJC renders its verdict, but that verdict speaks for itself. The PJC is not a party to a case. And this is a sort of an, it's just like in the American court system where the judge does not defend their own decision at the Supreme Court of the United States. The parties argue over whether the judge made the right decision, but the judge's decision speaks for itself. And it's the same with the PJC. Good questions though. Craig?
Yeah, the thing I'm wrestling with is this newly discovered evidence. Because normally I'm used to appeals. It's appeal on the record and there's not new evidence. Is there a procedure with the lower PJC where that new evidence could be presented to them in lieu of the appellate court?
Good question, and the answer is no.
Okay.
There is no procedure for returning a case to the lower PJC once the decision is rendered.
Okay, and then my question then is down here where we talk about the case remanded for a new trial. If on the appellate court, they're unable to figure out whether, number one, whether this newly discovered evidence should be considered, and is it really newly discovered? And also, does the newly discovered evidence change the outcome? I mean, could you remand the case to the lower PJC and ask them to consider the newly discovered evidence question, and if in particular, if that would make a difference in their decision?
Well, I'm hesitant to say that an appellate PJC can't do something, but I'm not familiar with a case where they would remand the case without finding a specification of error to be sustained. I think the only mechanism for returning a case to the lower PJC is finding that the lower PJC committed some kind of error. So I think the answer is no based on precedent, but of course, I guess you could try it and see if it gets challenged. Yeah, I mean, this is, and you guys are asking me great questions and I'm giving you my opinions as though I am the Chief Justice of the United States or something. I am not. And really everything I've said is my understanding of what the current authoritative interpretations of the Book of Orders say, but those are always fluid. And that's part of how our system is designed. And, if you had 3 other stated clerks standing here in the room, you might have 12 or so other opinions about those things. And so, I believe I'm giving you good information, but if you disagree, I honor your right to disagree, and those things can be tested through the judicial process. Anyone else? And I know you weren't disagreeing, Craig. I'm just saying I don't want to overstate my authority to say the things to you I'm saying. Martha?
Yeah, I'm kind of agreeing with where Craig's going with this. It doesn't really make sense. If you've got a problem and then maybe you have a dispute in testimony and a confession comes in, do you then have does the PJC who's hearing the appeal, do they do a trial de novo, or it would make so much sense to say, oh, wow, we now have a confession that there was a murder, so send it back and let them reach the appropriate decision than having the appellate court hear a trial de novo, right?
Yeah, you mean a completely new trial?
Yes.
I think what you're saying makes sense. If I were going to try that, if I were the Synod PJC and wanted to do something like that, I'd probably say you have a hearing and then you issue an order. And see what happens. If nobody appeals your order, then it's been successful. If they appealed it to the General Assembly, PJC, and said the Synod doesn't have a right to do what they did, then the GAPJC would have to rule on that. I think if I were going to do that as the Synod PJC, though, I'd want to point to what part of the Book of Order, what part of the rules of discipline I thought gave us, the Synod PJC, the authority to do that. Because we do operate under these rules of discipline that create, all of our authority derives from what is given to us in the Constitution. So if you can't find a way to justify it in the Book of Order, then I'd say you probably shouldn't do it.
Yeah, but if you're permitted to remand it, that's a normal reason to remand something.
Yes, but the remand permission, that's probably where I would lodge it. But I would also note that the permission to remand the case, that's one of the options you have when you have sustained a specification of error in a decision.
Well, that wouldn't be hard to do. You could say they made an error because they did not know.
Yeah, what I'd probably do.
I'm sorry.
No, well, here, so here's the specifications of error. Let me just go to the next slide. Here are the grounds for appeal. The written notice of appeal has to include, along with a whole bunch of other technical things, the names, the counsel, the copy of the decision. It has to name what the grounds are for the appeal. And they have to choose from this list of 7. It's D80105 A through G. And these are they. I find this list to be pretty broad. I find these terms to be pretty inclusive. The first one is irregularity in the proceedings. That's pretty broad. Receiving improper evidence, hastening to a decision, refusing a party the opportunity to be heard or present evidence, manifestation of prejudice in the conduct of a case. Look at letter F, injustice in the process or decision. May it please the commission. I argue that an injustice has occurred in the decision because later evidence has proved that the decision was wrong. If I were the Synod PJC in the scenario that Martha has laid out, I'd say you should hold the appeal hearing and let them make that argument and then sustain the error that later evidence proves that there was an injustice and remand the case for trial or reverse the decision. So that would be my advice, is actually use the structure that's here to sustain an error and remand the case or reverse it. So I've talked about these here. These are pretty broad, but it is important that, so there are preliminary questions in an appeal, just like there are preliminary questions in a remedial case. Here they are. And that fourth question this time is not whether it states a claim upon which relief can be granted. It's does it state one or more of the grounds for appeal in D80105G. You'd be surprised. I have seen appeals filed that do not do that. They just say they didn't like it, but they don't really, or that it was wrong, but they don't talk about why it was wrong. It's important that they do that. But if they do, you accept the appeal. And most appeals are accepted because those categories are so broad that almost every appeal does state one or more of those grounds. Questions? The other grounds, jurisdiction, standing, timeliness, again, they sort of speak for themselves, but do pay attention to deadlines. There are different criteria for different situations for how soon something has to be filed or with whom. When there is an appeal, you again proceed through several steps. Again, the PJC moderator and clerk get it first. They determine those preliminary questions. There's an opportunity for a challenge. Then the lower PJC's stated clerk, who has received from the clerk of the PJC the record of that case, puts it all together, any other relevant documents, and sends it to the stated clerk of the higher PJC, who distributes it to the PJC as a whole. One of the things that's worth noting here, and this is true at all of the levels of all of the kinds of cases we've been talking about, is that the parties themselves don't communicate directly with the PJC. They communicate with the stated clerk, who in turn advises them on process, tells them where they need to send things, but then shares material with the PJC. And if the PJC issues orders, you don't need to send them yourself. You give them to the stated clerk, who makes sure that they get to the parties. One of the things this ensures is that there's not ex parte communication going on, that you as members of the Judicial Commission are not having conversations with just one party and not the other. It also ensures that no individual PJC member is representing the PJC without the full body being addressed. You don't need to answer questions of procedure or how the parties should be doing what they do. That's the stated clerk's job. Your job is to wait for arguments to be made to you and then to decide them together. After the case has been accepted and the appeal process is underway, there is a timeline for briefs to be submitted, and those times are actually pretty clearly spelled out in the Book of Order. First, the appellant submits a brief, and then the appellee files a response brief. One of the great things about our appellate process, and again, this is a lot of what the Synod will have is appeals, but all of your decisions at the Presbytery or the Synod are subject to this appeal. It tends to really crystallize the argument because you have these briefs and these responses to briefs. So before it even gets to a hearing, there's a lot of written documentation of what is at issue in a case. A pre-hearing conference is held, and this again is an opportunity to sort of crystallize what is up for discussion and what the arguments will be about once you get to your hearing. Here's something that can happen, I'm jumping ahead a little bit to the decision, but something that can happen in an appeal. Just as you have to vote on every charge and just as you have to vote on every alleged irregularity or delinquency, PJC also has to vote on every specification of error in an appeal. But the PJC is empowered to rewrite the specifications of error for clarity. So if an appellant submits 27 specifications of error, but really the first 18 of them are all more or less alleging the same injustice in the process, the PJC can consolidate those and just vote on the one consolidated specification of error. It is important in the interest of justice to make sure that you're not overlooking anything the appellant asked for. You really do need to consider everything they said. But you can structure your decision in the way that you think brings the most clarity and help to the church, which might include reorganizing or consolidating specifications of error. And that's something you can do at a pretrial conference. If you see where it's going, a pre-hearing conference, you can suggest that maybe there's really just 3 specifications of error. Is it these? And see if the parties will agree. questions about what happens before the hearing? All right, so then you get to an appeal hearing. This is, again, a formal process, sort of like a trial. Interestingly, the Book of Order does not require some of the same things that a trial does. It doesn't require the reading of the preamble, for example. But I think you should do it anyway. And it doesn't say you can't. The GA PJC starts with the reading of the preamble before every appeal hearing. And I think you should too. There also does not include a provision for challenging the composition of the PJC before an appeal hearing. But again, I think that's wise to do. I think it's the most just and fair process. I also think you save yourself a little bit of difficulty later on if your decision is appealed on that basis, having actually already addressed it as a PJC. Then you have arguments. Pretty straightforward. You set the time limits. The appellant makes their arguments. The appellee makes theirs. The appellant has the right to speak last. And then there are questions from the PJC. So if you've ever watched or listened to Supreme Court of the United States oral arguments, it's a little bit like that, except that the justices of the Supreme Court always interrupt the attorneys, sometimes within the first few words of when they start speaking. That is not our practice for the most part. Instead, you give the time to the counsel for the appellants, then to the appellees. Counsel can reserve some of their time so that the appellant can go last, but then members of the PJC can ask questions. When all the questions are done, you're done, and you begin deliberations. Any questions about how an appeal hearing is conducted? It is with full formality and decorum. It does need to be recorded, since that hearing itself is subject to judicial review. So there needs to be a transcript. It needs to be recorded in a way that a transcript can be prepared if the case is appealed, just like a trial does. Martha.
I didn't ask earlier at the actual trial, but if there are objections, does the moderator rule on the objections?
Yes, in a trial, and I suppose in an appeal hearing, although there wouldn't be too many objections there, but in a trial, the moderator rules, and if either party wants to challenge the ruling of the moderator, or any member of the PJC wants to challenge the ruling of the moderator, the majority of the PJC can decide. On quick matters, sometimes that can happen very quickly. The PJC also can take a little break and deliberate and come back. I've been part of a trial where on the very rare occasions where there was a challenge to the moderator's ruling, the 10 of us on the PJC just sort of stepped back away from the tables, huddled, and decided together that we were affirming the moderator's decision. But yes, the moderator, I think you'll find that the parties very rarely challenge the moderator's ruling on an objection, because it doesn't take very long for that to become extremely off-putting. Any other questions? All right. So again, you go to deliberations. This will look a little bit familiar. You all have to be there. You need to be there the whole time. You vote on every specification of error, and as I said, you can show some discretion in consolidating those. We're going to walk through. I'm going to show you some sample decisions that show you kind of how that works, just in a little bit here. The question that's voted on in your deliberations, and usually in the groups I've been part of, we have the whole discussion, we understand where the majority is going to be, and then we take these formal votes at the end after the decision is written, but there is a formal vote on each question. Shall the specification of error be sustained? And the clerk of the PJC needs to record in the minutes what the vote was. You can put that in the decision, although you don't actually have to. The PJC has to vote on each specification or spec and record the vote. If no spec is sustained, so if all of the specifications of error are not sustained, then you have affirmed the lower PJC's decision. You're saying they didn't make any errors. If one or more of those specs is sustained, as we said earlier, then the decision could be affirmed because those errors were deemed inconsequential, or you could modify it as you see fit, set it aside with the question that was raised earlier. What does that mean exactly? You could reverse it, say we have all the information we need to know that that was the wrong decision, or you can remand it for a new trial. Just like your other decisions, this appellate decision is prepared while in session, and it becomes official when the moderator and the clerk sign it. They give it to the stated clerk, and the stated clerk distributes it as soon as practical to the parties. So in a disciplinary case, you'll remember the parties have to wait around because there's a censure hearing potentially and the pronouncement of a censure. In the case of a remedial decision or in the case of an appeal, the parties don't really need to stick around after closing arguments. You'll send them the decision when it's ready. Questions? All right. What I think we are at a good point to do is to take a short break. How about 15 minutes? Does that sound good? What we have left on the agenda is we're going to walk through a sample decision so you can see kind of how they're structured and the kinds of things that they might include. We're also going to look at some of the online resources available to you. I'll show them on the screen and show you where you can find them because I think they are very helpful to PJCs who are trying to make decisions once they're into deliberations and such. And then finally, we'll have time for open discussion, reflection on what you've heard, and lingering questions about how this process works. I think we'll be done easily by noon and maybe even a little before that. So let's take a 15-minute break. See you at...
Can I say something?
Yes, we have, and now a word from our sponsor, Valerie Young.
If you are a member of the Synod PJC, you have received an email from me. Please respond to the doodle poll so that we can set up our first meeting to elect officers. Break for 15 minutes.
See you at 10:35. 10:35. Pause recording. Very good. Sharing my screen. Sorry. Okay, so there's a lot of resources available to you to do this work. I know it feels like there's been this overwhelming amount of material, but you don't have to memorize it all. Most of what I've said to you is what's in the Book of Order, and the parts that aren't in the Book of Order that come from sort of general practice or authoritative interpretations, those can be found in other places as well. One of your best resources is your stated clerk. On behalf of the Association of Stated Clerks, I present this message. If you're on a Presbytery PJC, your go-to person for guidance is your Presbytery Stated Clerk. And if you're on your Synod PJC, that is your Synod Stated Clerk, Valerie. If they don't know the answer themselves, and believe it or not, sometimes we don't know all the answers off the top of our head, we should know where to find it or who to connect you with. And I really encourage you to take advantage of that resource and not feel lost and not go too far down a road that may depart from our regular practice. Now, I should say that you can use that resource freely and should until you're in your deliberations. You can use that resource even in your deliberations to ask for help with things like process, questions of procedure, clarification about what is required in coming to a decision and so on. Do we need a 2/3 vote on that or a majority? But the one thing your stated clerk is not going to do is they are not going to help you decide. If the question before you is a tough question of constitutional interpretation, was the presbytery supposed to do that? Is that really legal under the Book of Order? That's your decision. And the stated clerk can't offer you their professional opinion, even though they might have one. And I'm pretty sure they do have one. You are responsible for coming up with the substantive decision and not relying on your stated clerk for that. You'll be the ones held accountable for it. It'll be your decision that is reviewed. So the first piece of advice I have is to ask your questions before the case comes and get your stated clerk's help. But don't be afraid to ask those questions, because the stated clerk really is there to help you. There are other resources available. And one of those is the annotated Book of Order, which is the Book of Order, but with some enhancements, and it's available online. The place you find this, and actually several of the other resources, is on the General Assembly Permanent Judicial Commission webpage. I'm going to show it to you on the screen, but if you want to check it out later yourself, you can simply Google GAPJC and you're going to find it. I'm going to switch the screen that I share. I'm going to do this a little bit here and stay on your screen, and then get you this. All right. So hopefully you are looking at a web page on your screen now. This is the GAPJC homepage. It's at pcusa.org/GAPJC. It has changing material on the front page. Right now, it actually has the videos of our last 2 appellate hearings, which we didn't used to do on Zoom, but for the last 2 years, like everyone else in the world, we have. So if you want a little immersion in the work of the GAPJC, you can watch these hearings from start to finish. They were actually live streamed and the recordings are there. But what I'm directing your attention to is over here on the side, these links that are available, because there's a number of helpful things over here. The annotated Book of Order is the one that I think is most helpful. What this is it is a paragraph by paragraph. It is the whole Book of Order, but with a lot of very powerful links. So just by way of example, let's look at the section on those preliminary questions. So remedial cases, D6, you click on that and it shows you all of the sections. This material right in here, a remedial case is initiated by, that's the text of the Book of Order. But under each paragraph, you see a number of links. These are all of the times when the General Assembly has authoritatively interpreted the Book of Order, or when a PJC case has authoritatively interpreted the Book of Order, or even there are some cases here where they chose not to. So for example, right here, the third one down where it says amend rejected, this is where there was a consideration of an amendment by the General Assembly, but it was rejected. There's even the link to the minutes of the General Assembly. If you want to read exactly what they considered and read the action they took, you just click on that link and it's there. Going back, what you really need to pay more attention to are the things that they did approve or that the PJC approved. So if you're trying to examine, for example, what it means or what the General Assembly has said about the requirements for the preliminary questions, You say, okay, I know that that's in D60305, because that's where it says the moderator and clerk of the Permanent Judicial Commission examine the papers to determine whether the council has jurisdiction. What does that mean? How do I know whether the council has jurisdiction? Here's all these cases that addressed that question, and a little summary of what the PJC decided. So for example, someone filed in the case First Presbyterian Church of Palmdale versus the 221st General Assembly. They filed a remedial case against the General Assembly. And the case was dismissed by the GAPJC because the General Assembly Permanent Judicial Commission does not actually have jurisdiction over the GA. And if you needed to read the case to find when they made that decision and why, you could normally click on it and it would go right to it. But in that case, it's not going to. Now, if you want to click on the one, I have lost the internet. So that's on a different hotspot. You're not going to lose me from this camera, but you get the idea. You can actually click on of the GAPJC, and hopefully we'll reconnect because that's how I'm sharing my screen.
Guest.
I don't know. I think I was on yes, but I'm on again now. Okay, so hope for the best. All right. There's the case. So there's what happens when you call up a case, and it will actually bring up the full text of the GAPJC decision. You can read their rationale and why they did the things they did. You can read the way they voted on the specifications of error. A lot of attorneys or counsel for your parties will actually cite these cases. But if they're just quoting from them, you'll want to look up the full cases. To do that, you don't have to rely just on the annotated book of order. If we go back to that GAPJC homepage, another of the links takes you to a listing online of all of the Permanent Judicial Commission decisions that have ever been rendered by the General Assembly PJC. How many of you read this page regularly? See, I'm not laughing at you. Tim, good for you. I've read this page regularly since I was 19 years old. Yes, I know that this makes me a nerd. I accept the title. I'm a Presby nerd, but it's a good way to keep track of what's happening around the church in a lot of ways, and certainly to stay up to speed on what our polity says about key questions. I'm going to actually use one of these cases to walk you through a format for how an appellate decision might look. And then I'll show you a couple of others to show you how a disciplinary trial or a remedial trial decision might look. But let's just take this most recent decision we made, the Reverend Dr. Brian John, appellant, versus the Presbytery of New York City, appellee. The format of this case is pretty standard and just gives you a sense. We won't get into the substance of the decision, but just want to show you kind of how it looks. The decision starts there with a heading at the top. The name, those of you who are attorneys, this will look very familiar. This follows a format that's similar to courts. You state the parties of the case and what their standing in the case is, appellant, appellee. We list the number of the case and what this document is. This is the decision in order. All of our decisions start with an arrival statement that simply explains kind of the case history of how it got here. This is an appeal. It was decided by the Synod of the Northeast, Permanent Judicial Commission. In this case, by the way, this was actually a case that they dismissed for finding that the preliminary questions, that the complaint wasn't filed in a timely manner. So that's what was at stake in our appeal. Were they right to dismiss the case on those grounds? The jurisdictional statement is our own assessment that the appeal meets the preliminary questions. It's timely, they have standing, we have jurisdiction, and it states one or more of those grounds for appeal. Notice that's a single sentence. If you're saying yes to all the questions, you don't have to spend a lot of time explaining why. Then we list the appearances, who the attorneys were, the counsel rather, who spoke in the case. And then we give a history. This history is really helpful in a final ruling like this from the GA-PJC. It's helpful to tell the church about the case and why this matters and how it might affect them. In your decisions of a Synod PJC or a Presbytery PJC, that history can be really helpful should the decision be appealed. It helps to create the picture, tell the story of what occurred. The history should be a dispassionate recounting of the history. And if there are facts that are in dispute, you should note that in the history. But this isn't really part of your decision. This is kind of the background. And without getting into too many details, this is a case where some members of the church wanted to get rid of their pastor, and the COM did do that, but the pastor didn't, but said the pastor was being badly treated, and it's complicated. It doesn't really matter right now. Lengthy history, because it's complicated. Then you get to the specifications of error. This is the real meat of your decision on an appeal. You list the specifications of error, and in this case they are, we didn't rewrite them. These are right out of the appellant's notice of appeal. Pursuant to 80105G, the PJC of the Synod of the Northeast erred in constitutional interpretation. To wit, because the COM is not the presbytery, it had no authority to dissolve the pastoral relationship. We sustained that error. See discussion below. Specification of error 2, again, erred in constitutional interpretation. We sustained that error. And then we had discussion. Friends, it is really important in your decisions to offer rationale for why you've made the decision. I've said this before, I'll say it again. It's in part a matter of justice. It's a matter of fairness to the parties. They have taken the trouble of going through our judicial process. We owe it to them to explain why we've decided these things that in some cases have big impact on people's lives. It is also essential when your decision is subject to judicial review to offer that explanation. Like I said, you're not a party if your decision is appealed. The only thing you have to speak for why you decided what you did is your written decision. So take the time to be thorough and clear about the basis of your decision and what it exactly you found. Here's the lengthy rationale that we offer for why we sustained those 2 specifications. I do see your question, Craig, 1 second. And then there is one more specification. This is not a terribly common thing to do, but in this case, we neither sustained nor not sustained this specification because the specification itself was confusing. What had occurred is that the Synod PJC accepted that the complaint stated a claim on which relief can be granted, but they named what they thought the claim was, and the appellant didn't like that. They thought that it was a different claim. We didn't want to get into all that, so we just did this because the substance of the decision was really in what occurred with the first 2 specifications. So after speaking to why our rationale for each of those specifications, we had kind of a summary of our decision. So that's under the heading decision. And then we made an order. These orders follow a pretty standard form that yours should too. It is therefore ordered that the decision of the Synod of the Northeast is reversed and remanded to the Synod PJC for a trial, because they had dismissed the case and we were rejecting their dismissal of the case. It is further ordered that the stated clerk of the Presbytery report the decision and put it in their minutes. Further ordered that the stated clerk of the Synod report the decision, put it in their minutes. We also then tend to note who was absent from our meeting. And we had, in this case, an opinion concurring in part and dissenting in part that several members of the PJC signed, but not a majority. If a majority had signed it, it would have been the decision and not a separate opinion. It became official when the moderator and I signed the decision, and it was transmitted to the parties by my giving it to the stated clerk, who then affirmed that she sent it to them. That's the format of a decision, and you don't, that's all of our decisions are there online, so you can look at them for yourselves. Craig.
Yeah, quickly, was that decision, or I assume that decision was not done while in session, or just immediately after the hearing with all that detail?
Actually, it was. It actually was.
It said the hearing was on October the 8th and the decision was issued October the 10th.
Yep. We started at 9 a.m. with the hearing on Friday, the 8th. We worked all afternoon and into the evening. We got up Saturday morning, the 9th. We came back together. We worked several more hours. The case committee put some finishing touches on the draft and brought it back to us a couple hours later. And we voted on a final draft by late Saturday night.
Okay.
That's how the PJC operates.
So if you're in session and to do something like this, I mean, well, I would think it would take hours and hours. Then I assume then you can adjourn. And
yes, you can sleep. You can take breaks. You're still in session, even if you take a recess.
Okay. Okay.
Yeah, but what you don't do, you don't go home and then have someone else draft it and email it out and have people sign off on it. That's what you don't do. It has to be the group's shared effort and a joint decision. It isn't one person writing it and just having everyone else sign off on it. That's a really important distinction.
Thank you.
Yeah. Thanks for those of you who are providing links in the chat. I'm just sort of keeping an eye on that out of the corner of my eye. Thank you for the endorsement, Lori. Other questions? All right.
So Brian, this was remanded to the Synod for trial, not to the Presbytery. So the Synod was going to conduct a trial on this.
The Synod was the court of original jurisdiction, because the Presbytery was the respondent.
Okay.
And that is sometimes we just have to kind of get that in our head, because it is a little surprising sometimes. If the Presbytery does something wrong, allegedly, the Presbytery PJC is not the group that reviews it. It's the Synod PJC.
Got it.
And in this case, this is a good example. It was the Presbytery COM that did something, but because they were functioning as a commission, the Presbytery was the respondent. The COM was functioning as the Presbytery. Julie, you're muted. Oh.
Yes. If you had a member of the PJC who had to recuse him or herself for a particular reason, is the absences section of this statement where you would note that?
Yes, and you would say that they were recused.
Thank you.
In this case, these were just these were actually just vacancies, and sadly, one of our colleagues who died just a month before the trial. But in most cases, you would put in so and so was recused as a member of such and such a presbytery.
Thank you.
All right, so let me just quickly, I don't know that it adds a huge amount to your understanding, but I will just show you the slight differences in Presbytery, PJC, remedial or disciplinary decisions. And I'll show you, and I've hesitated about showing you a disciplinary case that involves a real person, but it's public. It's in the minutes of Presbytery, so I'm not betraying any confidences, but I don't mean to single this person out. This is an example, though, of a disciplinary decision that that was the result of an alternate form of resolution that was approved by the PJC. So in this case, they still came before the PJC with their resolution. We kind of abbreviated the arrival statement and appearances and the jurisdiction statement, and we included a brief history of what occurred. But instead of listing well, actually, we still did list the charges, but in this case, it's pretty much taken verbatim from the alternate form of resolution. Oh, I'm not showing it to you. I'm not sharing that part of my screen. I'm sorry. There it is. Okay, so here is a disciplinary case, looks similar in some ways. Remember that disciplinary cases are filed in the name of the Presbytery on behalf of the Presbyterian Church USA. Brief sections on the jurisdiction and the history. And in this case, mostly verbatim, we take the alternate form of resolution, listing the charges to which the individual pled guilty. Notice that charges tend to say what happened, place, time, and manner, but also what they violated. So in this case, it's provisions of the Constitution, the Book of Confessions, as well as the Scriptures. This is a minister who looked at pornography on his church computer and was discovered doing that. After that is listed the censure, which in this case was rebuke with supervised rehabilitation. Very specific outline of what will happen. Because this minister was not excluded from ordered ministry, even temporarily, there was no need to specify how they got restored. This simply needed to be carried out. If this, by the way, if this were not fulfilled, if the person did not complete the requirements of the censure, whose job is it to enforce the censure? Anyone remember? Is it the PJC? It is not. It is the Presbytery. So it would be the COM's job to work with this person, perhaps. Potentially, they could be brought up on further disciplinary charges if they failed to abide by the terms of the censure. The order ends with the pronouncement of the censure, and this was actually spoken aloud in open hearing. And then this decision was read on the floor of Presbytery. I was the clerk of this PJC in 2011. But I was thankfully not the stated clerk who had to read it on the floor of Presbytery. It's not a comfortable day for anyone. Questions about that? But that gives you a sense of the format of an alternate form of resolution. I'll show you just one more that shows you the format of a remedial decision in a trial, following a trial. This was an unusual one that I'm showing you in that the respondents were refusing to participate in the case. That's unusual, but the trial went on anyway. This was a case back in the period where some congregations were trying to leave the denomination. In this case, some members of that congregation filed a case against the session for their conduct. And so it was heard by the Presbytery PJC. Here you see, again, the statement of the parties, again, the arrival statement, a little bit of history of how it got here, that the moderator and the clerk ruled in the affirmative on the preliminary questions. There were a number of preliminary motions and orders in this case, and so those are briefly recounted in the history. We again included the appearances and explained, in this unusual circumstance, the absence of a respondent. And then finally, just like any other case, the specifications of error and the decision. This is a case where we as a PJC did in fact renumber and restate the specifications of error for clarity. We covered, you can see in that little summary at the top that there were 17 specifications originally. We reduced them down to 6. And here they were, that the session did this thing wrong, that was sustained. We didn't sustain all of the specifications. You can see that these votes were actually 6-0. The PJC was unanimous. A little bit of discussion. I'm just going to take a side note to say that this decision was actually quoted in a case before the Kansas Supreme Court, which eventually awarded the property for this church to the Presbytery and not to the portion of the congregation that tried to leave. But I digress. We conclude with orders. And this is the case where, besides simply saying that the action of the session was invalid, it felt that the justice of the church was well served. It's taking a while to get to where I am, but it's working on it. The justice was well served by a number of other directives to the session. And so you are functioning as the Presbytery if you're the Presbytery PJC, or functioning as the Synod if you're the Synod PJC. You can sometimes issue orders for what the lower council has to do, or must be directed not to do. And so that happened in this case. And there it is. Any questions about any of these decisions and how they're structured and how it works?
Brian, was that appealed to the Synod?
It was not, because the respondent session was by that point refusing to acknowledge the authority of the PCUSA. So had they appealed it to the Synod, it would have required them to acknowledge that they were still part of the PCUSA. I wish they had. Christiane?
I guess I'm a little confused, speaking about disciplinary cases now, about how much information comes out and who has a right to know it.
Okay, say more. What's confusing?
How does, if the pastor of a congregation is accused of some misdoing and alternate resolution, an alternate form of resolution is agreed to, which involves the pastor accepting censure, how does the congregation of the church ever know that, apart from if they send somebody to the Presbytery meeting where that's read?
That's a good question. I think in most cases, once it reaches the point of either filing charges or having an alternate form of resolution introduced, which remember does include charges. At that point, it's no longer confidential. So I think the Presbytery, through the COM, through the executive or general presbyter, through the ordinary course of its work with that congregation, is going to be working with them through this this disciplinary process that's taking place with regard to their pastor. Depending on what that resolution is, you know, it could in fact affect that pastor's ministry with the church. But I don't think anyone would be well served by not telling the congregation what's coming to the presbytery meeting in terms of a finding of guilt, even one that comes through an alternate form of resolution.
Okay, but going back a step, if the investigative committee concludes that yes, there may have been misdoing, but it does not rise to the level of a disciplinary charge being filed, they simply inform the stated clerk that that is their finding? Am I correct there?
Yeah, if the investigating committee determines that they are not going to file charges, then that's not an alternate form of resolution. That's a decision not to file charges. And they report that to the stated clerk, and the matter is concluded.
So the stated clerk has no obligation to report that to the congregation?
Yeah, on the contrary, the stated clerk cannot, because the stated clerk has never, I'm going to put an asterisk, I'm going to come back. The stated clerk has reported to the body whenever the allegation was received that an allegation has been received against a minister member. They don't say who the minister is, and they don't say what the allegation is. If the IC decides not to file charges, that's the end of the matter. And if the stated clerk says anything at all, what they say is that in that case I reported to you last November, no charges will be filed. Now, that doesn't mean that there aren't other people who know, especially if the allegation is that some sort of misconduct has occurred in that congregation, or that there's some financial misdoings. There's a lot of reasons why the COM or the Presbytery executive might have already reached out to the congregation. I think there's probably a good chance the investigating committee has reached out to the congregation as part of their investigation, and they know. So it's not that it would be an unusual case, I think, Christiane, where there'd be where the church wouldn't know about it. And at that point, it makes sense for them to be aware that if they were aware there was a judicial proceeding, and a disciplinary proceeding taking place, it would make sense for them to know that it has concluded. But it wouldn't be the stated clerk's sort of judicial responsibility to tell them, because officially the stated clerk never told them there was a process in the first place.
I see. Okay, thank you.
This is not an unusual question, or not just a hypothetical. This comes up partly because a lot of times if a person has gone through an investigation and no charges have been filed, they want, to whatever extent it's public that they were under investigation, they want people to know they were vindicated. But there's two problems with that. Usually the only reason it's public, in some cases, the only reason it's public is because they told people. That makes it not the stated clerk's job to then confirm that they were under investigation. The other problem is that a decision not to file charges really is not a vindication per se. It's a decision not to file charges. Remember that if an investigating committee comes to the conclusion that yes, something improper did occur, but we don't think we have the evidence to prove it in court, that's a decision not to file charges.
Or there's no relief that could be granted.
Or no censure that would be appropriate. It's a disciplinary case. I mean, for whatever reason, an IC might not file charges, but that doesn't mean they don't think the person did something wrong. And so you can't sort of announce a vindication by an investigating committee. Julie.
case in point, and a question about that. Years ago in Grace Presbytery, an investigative committee was getting ready to file charges, and the minister member managed conveniently to die the night before they were getting ready to present the charges.
Oh my gosh.
Yeah. My question, and having been on a preliminary investigating committee, you know, I can tell you exactly how that would have come out. But my question is then, where in the procedure is there any kind of relief for the people who were the complainants, who in this case had been sexually abused as minors over a period of years and were finally about to see some justice and had gotten the courage to come forward? And then when that death happened, had no chance then to have any kind of relief, in a sense. Where in our polity, obviously not the PJC, but who has some kind of responsibility for the pastoral care of those people, for anything at all, given that they attempted to proceed in good faith and then couldn't?
Wow, what a tough situation. I welcome the input of others to this question, because I think, as Julie suggests, it goes a little bit beyond polity to pastoral reality. I think first, to not answer your question, there is a process. There didn't used to be, but there is now, for what to do when the accused renounces jurisdiction. So it used to be, it still is the case, that when the accused minister or elder or church member renounces jurisdiction, essentially says, I'm no longer part of the PCUSA, that immediately ends the disciplinary process, because we have no authority to investigate and censure people who are not part of the Presbyterian Church. But it used to be that was the end of it, and the files were thrown away, and that was that. There now are provisions in the Book of Order for what you do in that situation. And one of the things you do is that the investigating committee comes out to the presbytery and says, here's what was being investigated against that person. And here's the stage of the process that was at, which might be, we had just filed charges against them, and these were the charges. You don't get out of publicity just by renouncing jurisdiction anymore. We also now have provisions that if you renounce jurisdiction, you have to, and you someday want to be restored to ministry, you have to go back to the presbytery from which you renounced, and they pick up the judicial process right where they left it off before you can re-enter that process. In the case of death, Julie, I don't know that we have a set policy or procedure. I think that's quite a renunciation of jurisdiction, but I don't know that those provisions apply in that case. And you're absolutely right. It is really important for the healing and empowerment of people who have been harmed to be able to be heard and know that they've been heard. I'd probably respond to it pastorally. If I were the stated clerk, I'd certainly want to reach out to those people and meet individually, talk with them about what had happened and where the process had been. I don't know that there's a lot to do judicially, at least under the rules as they stand now. Bernie, you were jumping in there.
Yeah, I was going to say, in that particular case, I happened to be legal counsel for the investigating committee. There was a lot of publicity. The matter was in Grace Presbytery because that's where this retired minister was, but all the conduct occurred in Africa when he was a missionary. And there had been newspaper articles, and so it was generally known. I think there was even a civil suit filed against the presbytery. But in any event, because this was the result or occurred in a missionary environment, and the victims by and large were the children of other missionaries, at the denominational level, they conducted a thorough investigation and issued a report that verified and confirmed. And then I think they provided counsel and support to the victims.
I remember some of that case, and you're right. That was sort of a unique situation, and there was a larger commission that went to work on that. Martha.
I spent, I'm honorably retired, a teaching elder. I spent most of my career as an interim pastor. Hey, and this kind of a situation did come up in our training, where you have some kind of, the pastor is killed in a terrible automobile accident or something, where there can be no immediate resolution with the person most directly involved. And I would agree with you, Brian, it is a pastoral issue rather than a judicial question. And could often be, or at least the case used to be, I've been away from it for a while, that the Committee on Ministry would arrange for a designated pastor who ideally could be on the scene within a week to start dealing with those issues immediately. Because they're just, it's an open wound that needs to be addressed.
Thanks for saying that, Martha. I appreciate that. And, these questions get to kind of the broader point that maybe in all of this talk about technical rules and regulations that I've been spouting at you for the last 24 hours, all of these cases, whether they're remedial or disciplinary, are about real people. They emerge as constitutional questions, but in fact, they are about people's lives and the lives of congregations and the lives of covenant communities that make up presbyteries and synods. And that's part of why I started with the preamble. All of our rules of discipline are toward an end, and that end is the same end as the end of the gospel. Love, compassion, justice, the peace, unity, and purity of the church. But it's not just an idea, it's actually people's lives, and everything we do, filing motions, rendering decisions, should be done with that in mind. Mary?
Kind of parallel to this conversation, some 20 years ago, I was serving in National Capital Presbytery. And while I was there, I served on what was called a congregational response team. And we were activated when charges were raised to be completely separate from the investigative process, to do the pastoral work of working with the session. How do you communicate with the congregation? How do you talk with the youth group? How do you, et cetera, et cetera, et cetera. That was very powerful work. It grew out of a recognition in that presbytery that wounded congregations frequently wound up getting re-wounded in because they hadn't dealt with their history. It's the only presbytery in my experience that has a process like that, or had a process like that. Is it widespread, and is it something we could encourage to handle this pastoral care piece?
Thanks, Mary. A lot of presbyteries do have a team or response panel or a committee like that. I will say that occasionally that's been complicating because sometimes they don't observe a clear boundary between the judicial process, and sometimes those response teams have gotten intertwined with the judicial process in ways that compromised investigations, for example. Having said that, I think it's still a good idea, and with some good leadership and guidance that can be avoided. But you're absolutely right. The investigating committee is not a good group to try to rely on for pastoral care. But if they're dealing with matters that are sensitive, that's a real need. And in our presbytery, the name of that group is the Safe Boundaries Response Panel. And they assign, the moment there's an allegation of misconduct, they assign members of the team to support the accuser and to support the accused.
Yes.
In whatever process might lie ahead. Zach had a question. Zach Hall had a question in the chat. A general curiosity question. Are you seeing an increase or decrease in the number of complaints in recent years? So I've talked with Flor Velez Diaz, who's Assistant Stated Clerk of the General Assembly and Manager of Judicial Process, about this. We are seeing a decline in recent years in remedial complaints and in appeals. So typically at a GA-PJC meeting, during my time on the GA-PJC, we have only on occasion had more than one case per quarter when we used to meet. We reduced our meetings from 4 a year to 3 a year, and we've rarely had more than one case at any one meeting. Back in the day, like the early 2000s, they would meet quarterly and they would have 3 or 4 trials or hearings at every meeting. It was ridiculous. But that was a more litigious time in the life of the church. So compared to the history, it's much reduced. I think there's still kind of a steady flow. And as I may have mentioned earlier, the remedial cases tend to focus very frequently on the actions of presbyteries in their work with congregations in turmoil. We're not debating the grand theological and complicated arguments like same-sex marriage or the ordination of LGBTQ people. We're not debating heresy. We tend to be focused on sort of one-off situations and whether the presbytery did the right thing in a particular conflict. Often it's about the last case I mentioned, the appointment of an AC to assume original jurisdiction. That's very frequently the subject of remedial cases. So word to all of you who serve in presbyteries, be very specific about the scope and the responsibilities that you're assigning to the AC. Be explicit about the limits and boundaries of their powers, because often that's where they fall apart. Now, to answer Zach's question on the disciplinary side, according to Flor, we're actually seeing an increase the last couple of years in disciplinary cases against ministers. Now, those actually are not appealed very often, and they're usually resolved in alternate forms of resolution, not always. But there have actually been, when she gets called upon to go in and do trainings, she's getting called into more and more disciplinary cases. You can use your own speculation about why that would be the case. But questions? This is your chance to ask any questions or share any reflections on anything we've talked about or haven't talked about. Elaine.
Can you talk about trainings a little bit? You mentioned Flor when she goes in to do trainings. Is that available to presbyteries?
It is. Now it's been a little bit upset by the pandemic, like everything else in our lives. But yes, Flor Velez Diaz is available to presbyteries and synods to do, well, frankly, shorter versions of what I've done here. Right. And particularly at certain moments when you know that the PJC is about to receive a disciplinary case, she can do a focused training on disciplinary cases. I can't speak to her schedule. I know that she has been pretty booked, and also there's a ban on travel right now by staff of the Office of the General Assembly. So they are doing all of that by Zoom. Maybe that's more desirable anyway. But that is the current reality. Yes, you should not hesitate, and really I should say your stated clerk should not hesitate to contact the Office of the General Assembly for assistance along those lines.
Thank you, Brian.
Anyone else? I would love your feedback either now or later on this training. I do think that it's a lot of information, potentially an overwhelming amount of information. I think if we were together in person, we could spread it out a little more and have a little more opportunity for small groups and discussions at break times that might make that a little more digestible. I still hope that the information, even though it was large in quantity, was also gave you a sense of the general principles. I know you're going to have to go check on the Book of Order when you actually put these things into practice anyway. But I hope that you have a sense of how the system works and why we do things the way we do, that allows you then to make sense of the details when you go and find them. Bruce.
I will admit to having been through one of these in a row. So there's hardly any precedent that I have. They're painful, they're difficult, and part of the pain and part of the difficulty is opening up the Book of Order and trying to wade through that. We had the help of a good clerk and got through some of this. I have heard, or it has been alleged, that there is going to be some major overhaul of this Section D. And is there any available scuttlebutt on what that might be that would take some of the edge off of this?
I have a slide about that if you'd like. Yes. So what
I will shill for you all day then. That's not bad.
Thank you. That was really well. I'm so glad you asked. I'm finding that slide out of a different presentation, but what Bruce is referring to is that there is a proposed revision to the entire rules of discipline. So everything you've just invested 24 hours of your life in learning about could change, but don't worry, it's not really changing that much. It will look and feel different. Let me show you a few of the changes that are being proposed. I'll show you this slide. So there's a task force that was created at the 2016 General Assembly. It didn't get appointed until the next year. They were supposed to give their final report to the 2020 General Assembly. We all know that that one went to Zoom and they eliminated all the non-essential business. So it's coming to this summer's General Assembly. So even if it is approved there, it'll go to the Presbytery for ratification and wouldn't take effect until the summer of 2023. So you've still got a little while left with the current rules of discipline. And that's only if this gets approved. A lot of the changes that it would make involve kind of the way things are organized. So several times we've been frustrated over the fact that to find out how you do this thing, you have to turn to here, and then you have to go back here for the next step of the process. One of the changes they're trying to make in the rules is to correct that. So there's going to be a section on disciplinary cases, a section on remedial cases, a section on appeals, and it will track the whole process from start to finish. More like the way I did this presentation, actually. Another thing that they're doing is incorporating a lot of what I showed you in the annotated Book of Order, all those authoritative interpretations that say this is how we practice the Constitution, but that aren't in the Constitution themselves. They're going to put a lot of them in. They've been guiding our work for years, sometimes decades. There's no reason they shouldn't be included in the Constitution. So that's part of their changes that they're making. There are some other things they're doing that I think are maybe more substantive, and I really appreciate them. They are really lifting up the differences between secular process and church process. Even though we always have said that, when you read the rules of discipline, sometimes it does feel like you're reading the federal rules of legal proceedings. And they really just because we don't call them plaintiff and defendant, that's what they are. They are trying to really kind of deepen the theological difference between an ecclesiastical process and a secular process. They also greatly expand the conversation about alternate forms of resolution. And they're explicit about the different forms that it could take. Mediation, alternative dispute resolution. They offer more clarity about who can be brought into those processes and what the possible outcomes can be. They also, I'm thankful for this, they offer more clarity about what a censure should look like. Particularly a censure like temporary exclusion from ordered ministry with rehabilitation. How is it that you carry that out? Who enforces it? Who discerns whether a person has completed the requirements to be restored to ministry? That's all just sort of left in the Book of Order for presbyteries to figure out. This is going to give a little more direction. The other substantive change is that currently there's a 5-year limit, a statute of limitations, if you will, from the date that an offense occurs to when a person can be charged with it. That would be eliminated in the new rules of discipline. Right now, that time limit has been eliminated in cases of sexual abuse, but it would be eliminated for all offenses. And then finally, even before the pandemic, they were proposing ways for PJCs to operate electronically. Interestingly, the GA PJC issued a ruling that strongly discouraged electronic trials and hearings. That was in late 2019. Oops. So anyway, the new rules of discipline will bring us into reality, whether they intended to or not. Bill.
Yes. Would you ask them to please make clear, if they haven't already, as to whether or not these new rules are going to only apply to matters filed after the effective date, or are they going to be as to all matters pending and in the future? Because it gets very confusing and people challenge, well, you're not in those rules and that kind of thing.
With previous amendments, it is understood that the Book of Order, in effect, at the time a complaint is filed, those are the rules that apply throughout that proceeding. So you'll see that as a footnote in a lot of GA PJC decisions that will say, because this complaint was originally filed in 2017, the Book of Order from 2017 to 19 is the one we are using for this case. I don't know, Bill, how that will play out for something like the 5-year limit that I just mentioned. Does everything that occurred in the lifetimes of all ministers now suddenly become available for prosecution? God, I hope not. But no, it is that is something that will end up having to be interpreted, I imagine.
It is much easier if they would state whether or not it is, as opposed to, well, it's generally accepted. So,
I think, as I said, I think most of the changes are not so substantive that there will be a whole lot of impact along the lines you're talking about. The big difference would be if there's changes to timelines, filing deadlines and that sort of thing. A bigger substantive decision like that 5-year time limit, they should be clear about. I agree. Someone asked in the chat if the proposed draft is available somewhere. Yes. I think it might even be linked from that same GA PJC homepage. Let me see. No, it's not. It is linked from I don't know. but you can Google it. Proposed Rules of Discipline, PCUSA. Your stated clerk might also be able to direct you. Actually, it's also in PC Biz. It's in the papers that are going to this year's General Assembly, because it's actually a proposal there. And you can read the exact draft and also their rationale that they've submitted to the Assembly. Tim.
At one point in the discussion about the changes to the rules of discipline, there was a conversation about the degree to which we could compel, in a case of sexual misconduct or other misconduct, compel the minister to testify, to participate in the process, which often we've run into cases where that the minister doesn't want to participate in the process or does it, slowly or whatever. Where did that end up? I know there was some conversation about to what degree they could compel and wanted to compel people to testify, to participate in the process.
I'm not sure where that landed from where it started. I know that one of the arguments being made when that first came up was that there already are the tools in our existing rules of discipline for compelling people to participate, in the sense that if they don't, they can be that can be treated as a disciplinary offense in and of itself, not cooperating with the process. But I think some people have said there should be some kind of equivalent of holding people in contempt, more or less, kind of a bench ruling that you aren't complying, so now you will be disciplined. And that ultimately, I don't think is part of their proposal. I don't think there is. I think the only way to discipline someone remains the full process of investigation, charges, and being found guilty. But we can compel ministers. We just don't have an armed branch that can actually drag them into the room.
Bench warrant would be nice.
Yeah, I will leave it to you to bring an overture. I mean, we'll see where it goes. Anyone else? I'm looking for that document. I can't find it off quickly, but it is widely available. So you can find those proposed rules of discipline. Are there any other questions? Are we ready to break? Are we ready to be done? Well, friends, I have greatly appreciated this chance to be with you. Your questions have been wonderful. Your reflections have been meaningful. I'm excited for the presbyteries of the Synod of the Son. I think you're well led, and I look forward to not having any appeals from any of your PJCs, or including your Synod, in the next 2.5 years that I have left on the PJC. Thank you so much for welcoming me and for the chance to be together. If there's nothing else, I would, do you need to say anything else, Valerie?
No.
Okay.
Thank you. Just thank you. Thank you.
Thank you. You're
very
welcome.
much, Brian.
It's my pleasure. Let's close in prayer. God, we are grateful for time together, grateful for your calling on our lives. Grant us discernment, grant us peace. And we pray even now for those members and ministers and congregations and presbyteries who are not mere parties in cases, who are not mere complainants and appellants, but are in fact children of yours, loved by you, made in your image, and called to love and serve you and serve the world. May we be instruments of your work in their lives and sensitive to your work in our own. And we pray it in Jesus' name. Amen. Thank you, friends. Appreciate your kind words. Blessings.